Tractate Yevamos discusses a bit of a unique topic in the laws of marriage. There's a concept called the Levirate marriage, or Yibum, where essentially a woman whose husband passes without leaving any children, her brother-in-law, the deceased husband's sibling, has a responsibility to marry her in his stead. If they don't want such a marriage to go through, there's an additional process called Chalitzah, a ceremony which annuls this bond and allows her to marry whoever she wants. Chapter 1 will begin the discussion of these laws. The first Mishnah says, in regards to the laws of Yibum, the Levirate marriage, and Chalitzah, the annulment of a Levirate marriage, there are some cases where the relationships of the people involved make it so that neither Yibum or Chalitzah are permitted to be done. If the deceased husband had married his brother's daughter, obviously now the brother is not allowed to perform the Levirate marriage, which would be to his own daughter. If the deceased husband had married his brother's granddaughter, either from his son or daughter, if the deceased brother had married his brother's wife's daughter or granddaughter through son or daughter, if the deceased husband had married his brother's mother-in-law, or his mother-in-law's mother, or his father-in-law's mother, or the deceased husband married his brother's maternal half-sister, or his brother's mother's sister, or his brother's wife's sister, or his brother's maternal stepbrother's wife, or the deceased husband was married, the brother did Yibum, marrying the widow, along with a co-wife, and there's a later-born brother, he's now exempt from marrying both of those women, if the older brother also passed, or if the case is that the widow is his daughter-in-law. So, in all of these cases, there's an exemption for Yibum and Chalitzah for them, all the wives discussed, and their co-wives, and their co-wives' co-wives. Their co-wives would be permitted to the husband's brother if the first wife died beforehand, or they refused to marry him when they came of age, or they were divorced, or they were found to be an ailonis, a unique disorder where a woman has male characteristics, often defined as Turner syndrome or some other physical disorder, which terminates a marriage. Such a case is not possible by the mother-in-law, mother-in-law's mother, or father-in-law's mother by an ailonis, or them refusing the marriage, as those cases are where they had children. This concept is further defined in regards to the co-wives. Furthermore, with any of these cases, if the wife was able to refuse the marriage when she came of age, but decided to marry him anyways, the co-wife requires Chalitzah to nullify the bond if her husband dies, but she cannot do Yibum if they want to get married. The Gemara asks, why don't they just teach the case of a wife's sister first, as that's the verse this is all derived from? We say the reason that the case of the daughter goes first as that was learned from scriptural exegesis, so it was said first because they were fond of the teaching. Actually, all of these are derived from scriptural exegesis. It's just that the actual initial prohibition against marrying your daughter is itself derived from exegesis, as it's never actually explicitly written in the Torah. The remaining order is by how closely related the individuals are, which is explained. It specifically says they exempt their co-wives, not forbid them, since the marriage is only forbidden by the laws of Yibum. Outside of that, it would be a permitted marriage. It also says they're exempt from Chalitzah, and says at first, to say this is like the opinion that Chalitzah is actually the preferable option. There's some further opinions, and it goes through all the verses that explain how all of those listed marriages are forbidden by the laws of Yibum. The verses are further discussed. It also discusses some verses on the laws of tzitzis and shadness, which are juxtaposed, and some unique laws from those. This goes further. It also goes through some additional verses which teach specific laws by these concepts. It goes through some additional qualifications on the laws of shatnez and tzitzis, and also explains the necessity of certain other verses. There are further these discussed. It also goes through the necessity of having several of these potential marriages excluded by the Torah based on potential derivation by several other verses and concepts. The principle is the question if a positive commandment can generally override a kares prohibition, which we try to bring from other topics, like by punishments in regards to the violation of Shabbos, but we can't, and we end up unable to explain why the Torah excluded a wife's sister from Yibum. Rather, we say it was necessary to teach for necessity of learning other concepts from its scriptural exegesis, meaning it needed to be singled out, as otherwise you might have thought that the prohibition of a brother's wife was singled out to exclude this, so we list this also to say that's not the case. Others disagree, and say that you might have mistakenly derived its permissibility by a wife's sister from the permissible case of the typical brother's wife, which is explained further based on some similar concepts. This is discussed further with even more suggestions as to why the Torah specified this concept. These are further debated in regards to the specific wording of verses and the concepts that could be implied from them. There's further discussion on what's derived from certain verses on this topic. One sage attempts to take a ruling cited by a later Mishnah that if the marriage is forbidden to one brother, it could be permitted to a different one, which would apply to a case where there's a sister who's another sister's fellow Yevama, who can do either Yibum or Chalitzah. This case will be discussed more in a later Mishnah, but there are many opinions as to which of the cases we discussed that this applies to. There are other suggested cases mentioned in regards to these situations, which are additionally discussed. We also try to suggest to add another case to the list, according to one of the opinions, where the deceased husband's brother did Chalitzah, and then afterwards betrothed her and then died. She and her co-wife are exempt from Yibum and Chalitzah from his brother. Others answered that this wasn't listed as though co-wife's co-wife doesn't apply here, unlike by all the other cases. That's if you hold the marriage is prohibited under penalty of kares. If you hold that it's just a negative commandment, then that's the reason itself. This is debated based on verses. The debate as to this level of punishment is argued further. Another case, a co-wife and a wife who committed adultery are both forbidden to do yibum, and therefore exempt from chalitzah, which is based on a verse. Others disagree, saying that this rabbinic enactment was made in the manner of a biblical law, compared to a case of a biblical sota. This is argued on further with discussion on particular cases of remarriage after divorce in regard to the laws of Yibum, which is debated among several opinions. Besides for the situation with an adulterer, the co-wife of a wife who refused to marry the brother cannot do Yibum to marry him, the one who was refused. This was said as a precaution to avoid the similar case of a brother who was with the other's daughter who refused to marry him along with her co-wife. Both are impermissible, which is discussed. Also, the co-wife of an Ilonis, who cannot have a child, is forbidden based on a verse. This is discussed. A related point, typically, preventing conception is forbidden by Jewish law. However, there are 3 exceptions to this rule, where women can use a cloth or similar to prevent conception. The first is a minor. Now, it goes without saying that marriage or cohabitation with a minor is very strictly forbidden on many levels in Jewish law. However, it's saying that, God forbid, in the event that a minor is in such a situation, she would be halachically permitted to take any step necessary to prevent conception for the sake of her own health. Other sages say that God will have mercy on her and keep her safe. The next is a pregnant woman who can do this for the safety of her fetus, and the third is a nursing woman, as it could cause issues with her milk. There's debate as to the level of physical development in a girl that constitutes her being a minor, and it says that if a woman gives birth, legally, she's assumed to be beyond these stages, meaning it would never be necessary to check. The remaining points from the Mishnah are qualified along with verses. New Mishnah. Sex relationships by Yibum are stricter than all the ones listed earlier, as they're related paternally. A mother cannot do Yibum to marry the son's paternal brother. You can't end up marrying your father's wife, or your father's sister, or your paternal sister, or the wife of your father's brother, or the wife of your paternal brother, meaning after they had kids. So, they can't do Yibum. Beis Shammai actually allowed the co-wives of the first 15 cases to marry the wives' brothers. Beis Hillel says no. Practically, this means if they did Chalitzah, Beis Shammai says this was valid, and they can no longer marry a Kohen, while Beis Hillel would say that nothing happened and they can. Or if they did Yibum, Beis Shammai would say that was valid, and they can still marry a Kohen if their husband dies, while Beis Hillel would say no. In spite of Beis Shammai and Beis Hillel's disagreement by this, they would still marry into each other's families, and similarly, in spite of the fact that they disagreed frequently by the laws of impurity, they would still eat food together using each other's utensils. The Gemara debates the verses that source these opinions. Some say Beis Shammai holds like he does, as he says a prohibition does not take effect upon another prohibition. It also discusses the necessity of the example by marrying a Kohen. It's because some instituted that co-wives should all just do Chalitzah to be safe, so it specifies this to say that wasn't implemented, hence the different opinions. There's an additional point on the prohibition against creating different factions in regards to the performance of mitzvahs. An exception is the reading of the Megillah, which could be done on different dates depending on the region, as further discussed earlier in Chapter 1 of Tractate Megillah. So there's a question as to how Beis Shammai and Beis Hillel could have their own practices in regards to the marriage of co-wives on this topic, which is seemingly in violation of this principle. So it's said that actually Beis Shammai just followed the law according to Beis Hillel, and there's a number of suggestions why. There's reference to the incident where a voice from heaven said that we always follow Beis Hillel. Possibly it was because Beis Hillel just had the majority in his school, which is why we hold like him. There are a number of reasons given. Others say the concern of factionalization only applies where one court rules partially like both opinions, not where there's 2 courts in a town, both of which follow the different opinions. There's further discussion on this topic, and this is all qualified further. There's additional debate based on many cases if Beis Shammai did end up holding like Beis Hillel in these laws. There are even further specific cases discussed to try to figure out this topic. In the end, we prove from the quoted case that the co-wife of a daughter was allowed to marry the brother of her deceased husband, which is the opinion of Beis Shammai, implying that they did actually hold like their own opinion. The whole case is further quoted, along with a few additional points, such as which peoples we accepted converts from. Specifically, the Talmudians are not accepted, possibly as they're descended from the slaves of King Solomon, possibly because they're descended from the women who were assaulted during the destruction of the first temple. There are related verses on this discussed, and there are some specific regions and towns mentioned on this topic. And that's the end of Chapter 1. Chapter 2 of Tractate Yevamos further discusses the laws of the Levirate marriage, the laws of a woman who either marries her brother-in-law after her husband's passing, leaving no children, or the rejection of this marriage, called Chalitzah. The bond that's created between her and her brother-in-law that forces her to either marry him or do the Chalitzah ceremony to not marry him is referred to as Zika. The Mishnah says, in the case where there are two brothers and one passes childless, and then there's a third brother that's born, the second brother married the first brother's wife through Yibum, and then he also dies, the third brother is exempt from Yibum and Chalitzah from both brothers' wives, as he's a non-contemporary brother. He wasn't alive when he died, and the second brother's wife was also her co-wife. If the second brother had only betrothed the first brother's wife and then died, the second brother's wife cannot do Yibum, but must do Chalitzah. The Gemara clarifies points on the wording of this, saying the widow can be referred to as the widow of the first or second husband. It also brings the source for these points from verses. Some say, if a woman was waiting to go through Yibum, but then died, the man is allowed to marry her mother. Some suggest this, as this opinion holds there is no Zika bond between the widow and her brother-in-law, but he can only marry the mother after she passes, as he has the first obligation to marry the widow. Others disagree, saying there is a Zika bond, and it's debated. These opinions are challenged based off many related cases. This is debated further. Some clarify the opinion to be that the Zika bond does exist, and it doesn't vanish after the widow dies, hence the issue with marrying the mother. There are a few different opinions on this topic, but we do seem to hold that such a bond does exist. New Mishnah, if there were two brothers, the first dies childless, so the second does Yibum, marrying his widow, and then a third brother is born, and then the second brother died childless. Again, he's exempt from Yibum and Chalitzah to both brothers' wives, as he's a non-contemporary brother to the first. He wasn't born yet, and the second is the other's co-wife. If the second brother had only betrothed the first brother's wife before he passed, his widow cannot have Yibum and must do Chalitzah. Others disagree with this case, saying if both brothers married and died, the third brother should do Yibum or Chalitzah to either of them. The Gemara explains the logic of the disagreeing opinion, saying it's due to an apparent redundancy essentially between this Mishnah and the previous. There's further discussion on this. The opinions are argued on. There's different interpretations of the disagreeing opinion as to what exactly is going on. Some say he's referring to a case where the first two brothers married sisters, and also a mother and daughter, like this. Others disagree based on a source. Alternative suggestions are brought, and it's further debated. We bring the case from a source of a few listed cases to find the one where the opinions disagree. There are several of these cases, and the last one is where a brother does Yibum, and then a third brother is born, and then the second brother dies childless. Some would say both are widows and exempt from Yibum and Chalitzah, and the disagreeing opinion would say he can do Yibum or Chalitzah with either widow, as the third brother and them only ever were permitted to each other, and were never in a state of impermissibility to each other. He wouldn't disagree with the first opinion if he was born before Yibum was done. There's actually a number of particular cases discussed, which are debated between the two opinions, but they can be summarized pretty concisely into this chart, so this is basically the whole discussion. They're discussed a bit further though. New Mishnah. Generally, regarding the widow, if she's forbidden to marry due to the general laws of who you can and can't marry the brother-in-law, she cannot do Yibum and is exempt from Chalitzah. If they can't marry due to a mitzvah or due to sanctity, which will be explained, they can't do Yibum, but they require Chalitzah. If there are two sisters who both are widowed by brothers, the third brother can do Yibum or Chalitzah with one of them if it's impermissible for him to marry the other. Unable to marry due to a mitzvah is the instituted prohibition against marrying secondary relatives. And unable to marry due to sanctity is the prohibition against a widow marrying a Kohen Gadol, or a divorcee or similar to a Kohen, or a child of a forbidden union, or a Nesonite to anyone, either as the husband or wife. The Gemara says the general rule comes to include the co-wife of an Ilonis, again someone with Turner syndrome essentially, as exempt from Yibum or Chalitzah, according to one opinion. Others say it's actually disagreeing with this opinion. The remaining points are for the qualified, and there are some unique exemptions discussed. It also gets into some other cases. What if a Kohen Gadol impermissibly did Yibum with his brother's widow? There's disagreement if the widow's co-wife is still connected to the widow in regards to the laws of Yibum. There's further discussion on this, some sources, and a list of all the secondary relatives as to what is considered to fall into this category that you cannot marry. Here's a chart listing basically all of the biblically prohibited marriages that are specifically written and all of the rabbinically forbidden marriages of secondary relatives. These are for the qualified, along with some specific cases, and they're all discussed further at length. Others say the chart is as follows, including all of these in addition. This is for the discussed, again with some particular cases, and some add that converts have no rabbinic prohibition from marrying these secondary relatives. On the topic of converts, it says that paternal brothers who converted can testify together, and maternal brothers, some say they can, some say they can't, but if they did, it's still valid. This is because conversion basically resets all of your relationships. You're considered like a newborn, and all prior familial relationships don't exist. Now, not everybody's aware of this, so we're still strict by marriage, that they can't marry their relatives after they convert, but a court knows these laws, so they can accept their testimony. New Mishnah. If someone has a brother of any kind, Yibum will apply, and he's considered his brother by everything, unless the brother is from a Canaanite maidservant or idolatress. If you have a son of any kind, that makes Yibum no longer necessary, and the son would be liable for wounding or cursing his father, and is his son by everything, unless he's from a Canaanite maidservant or idolatress. The Gemara says, a brother of any kind includes even a bastard, which is necessary to say based on some verses. Them being brothers for everything is to include them being impure for each other, which is also necessary from some verses, and this is further explained. A son of any kind is to, again, include a bastard. Verses are discussed, and this is all qualified further. There is additional discussion on these verses. It mentions famously, based on one of the verses, that a person is Jewish based on his mother alone, meaning if a person is born to a non-Jewish father and a Jewish mother, he's considered totally 100% Jewish, and if he's born to a Jewish father and a non-Jewish mother, he is not considered Jewish. This is further discussed. New Mishnah. If someone betrothed one of two sisters, but he's not sure which, he has to divorce both of them. If he died without divorcing them, his brother must do Chalitzah with both of them. If the dead brother has two brothers, one must do Chalitzah and the other can do Yibum. If both brothers married both sisters, they don't need a divorce. If two unrelated men betrothed two sisters and neither knows which he betrothed, both of them must give a divorce document to both of them. If both men died childless without divorcing and each has a brother, both must do Chalitzah with both sisters. If the first dead guy had one brother and the second had two brothers, the single brother should do Chalitzah with both, and the first of the two brothers should do Chalitzah and the other can do Yibum. If the two brothers marry the sisters, they don't need a divorce. If both dead guys had two brothers, one of each brother must do Chalitzah with one, and the others can do Yibum with the sister that the opposite brother did Chalitzah with. If two of the brothers did Chalitzah with both, one must do Chalitzah and the other can do Yibum. If they both married them, they don't need a divorce. The Gemara tries to learn from this that marriage is still valid even if you cannot legally cohabitate, but we say no, as the marriage made initially was where they could cohabitate, and it was only after that the sisters got mixed up. These points are further discussed if we can learn this from any part of the Mishnah. The explanation of the cases are further qualified. New Mishnah. The commandment is for the eldest brother to do Yibum, but if the youngest did it, it's still valid. The Gemara cites and discusses sources for this. New Mishnah. If there's a rumor about someone that he cohabited with a slave woman who was later set free, or with an idolatress who later converted, he cannot then marry either of them. But if he did, they don't need a divorce. If there's rumors about someone cohabiting with a married woman, and the court rules she should divorce her husband, she cannot marry the other man. And if they do, they must divorce. The Gemara discussed these cases, and there are some additional points on these topics. New Mishnah. If an agent brings a divorce document from abroad and says that it was written and signed in his presence, he's not allowed to marry the divorced woman. If someone testifies about a man that he died, or he or we killed him, the testifier is not allowed to marry the dead man's wife. Some add that if the testifier said, I killed him, the woman cannot marry anybody now, as the witness had admitted he's a sinner, and thus disqualified his own testimony, leaving her unsure if her husband actually died. If he said, we killed him, then she may remarry. The Gemara explains these cases. Basically, it's as we rely on the testimony of these individuals, the marriage is therefore impermissible after. They're further discussed. It also explains the difference by saying we killed him. It's as he's saying I was with somebody who killed him, which is discussed. New Mishnah. If a sage prohibited a woman to be with her husband by not nullifying a vow against her from being with her husband, the sage may not now marry the woman. If a woman refused the husband or did Chalitzah before a sage in court, the sage is permitted to marry her as he was doing this as a court function. The Gemara explains points on these cases along with a debate. If they did marry by the vow case, if they actually need to get divorced or not. New Mishnah. By all of the above cases where a testimony or a court function or similar prevents someone from marrying the involved woman, this does not apply if the man was married at the time and the wife later died. Also, with all of the women, if after the incident they married somebody else and then were divorced or widowed, they can then marry the guy from the case. Also, the women are all permitted to the sons or brothers of those involved in the case. The Gemara discusses these points in regards to marrying the brother of the involved individual. That's allowed as either there's no concern of her meeting up with the guy through the relative, as men don't typically visit each other, or it's because the husband won't permit such a thing, as it'll lead to an impermissible marriage on his end. This might be a concern by a father to son, but a son has respect and awe of his father, so he won't cohabit with his wife. And that's the end of Chapter 2. Chapter 3 of Tractate Yevamos further discusses the laws of the Levirate marriage. The Mishnah says, if there were 4 brothers, 2 of which were married to 2 sisters, and they both died childless, they should do Chalitzah to the other brothers and cannot do Yibum. If they did marry, they must divorce. Some say it's actually dispute if they need to divorce or not. If one of the sisters was forbidden to one of the other brothers as they were related, he can't marry her, but he can do Yibum with her sister, and the other brother can't marry either of them. If the sister was prohibited to the other because of a mitzvah or because of sanctity, they must do Chalitzah, but they cannot do Yibum. If both sisters are each forbidden to one of the brothers as they're related, they're allowed to marry the other one. The Gemara tries to argue based on these cases the implication of the existence of a zika bond, a connection of a sort, between the widow and her brother-in-law, but we say no. The principal issue with this case as to why the Yibum is forbidden is as you can't negate the obligation to do Yibum from yourself, and if you marry one and the other brother dies, this will cause this issue. It doesn't mention a case of 3 brothers, as that's obvious that he's negating the obligation by marrying one of them, and we don't mention 5 brothers, as it's very unlikely that 2 brothers would die. A similar case, if there are 3 sisters that marry 3 brothers, and all 3 brothers die, and there's 2 brothers to do Yibum with, one brother does Chalitzah with one brother does Chalitzah with the other, and they both do Chalitzah with the third. The logic of this is further explained, and some actually disagree, saying that one brother can do Chalitzah for all of them. According to this latter opinion, there are a few particular cases discussed as to what he holds like and why in regards to these laws. There's further discussion if the principle of Zika applies, how, and where. This is further discussed, along with the necessity of all the cases brought in the Mishnah in regards to this principle. There's further qualification on these cases. New Mishnah. There were 3 brothers, 2 of which were married to 2 sisters, or to a woman and her daughter, or even granddaughter. If they became widows, they need Chalitzah, but they cannot do Yibum. But others exempt them even from Chalitzah. If one of the widows couldn't marry the brother-in-law because they were related, he may do Yibum with her sister. If she couldn't marry him because of a mitzvah or sanctity, they do Chalitzah and cannot do Yibum. The Gemara explains the necessity for this repetition to clarify the opinion that says that they're exempt from even Chalitzah. Still, if there are 2 sisters where one can't marry the brother-in-law due to being related, according to this, the other sister can still do Yibum. This is further discussed. New Mishnah. If there's 3 brothers, 2 of which are married to 2 sisters, and the third is unmarried, if the first brother dies childless and the third brother betroths his widow, and then the second brother dies childless, Beis Shammai says the third brother remains with his betrothal and the second widow does neither Yibum or Chalitzah as she's his wife's sister. Beis Hillel would hold that he must divorce his betrothal and do Chalitzah with both wives. The Gemara says that this is to dispute the opinion of a Rabbi Yehoshua, which is going to be discussed way later. There's further discussion on the opinions, how they hold betrothal affects which stage of marriage exactly, which is debated, and after a bit it's said to only affect the stage of Erusin, the earlier stage of marriage, where you give a ring or a betrothal document, and this is further discussed. New Mishnah. If there were 3 brothers, 2 of which married 2 sisters, and the third married some other woman, the second brother died, so the third brother did Yibum, marrying the second brother's wife, and then died. The first brother doesn't marry either of them, as they're his wife's sister, and her co-wife. If the third brother only betrothed the second brother's wife before dying, the first brother does Chalitzah with his wife and doesn't do Yibum. The Gemara clarifies, if the third brother didn't even betroth the second wife, the first brother could do Yibum, implying that according to this opinion, the Zika bond does not exist. New Mishnah. If it was the same situation as before, only the third brother, the one married to the unrelated woman, died first, the second brother did Yibum to marry his widow, and then he died, the first brother cannot do Yibum or Chalitzah, as they're his wife's sister, and her co-wife. If the second brother betrothed the third brother's widow and then died, the first brother must do Chalitzah and cannot do Yibum. The Gemara debates the necessity of this case, as it's very repetitive of the prior, so it's explained that originally this one was taught, and then they switched the rulings on the prior one, and decided to teach it first, but they decided to keep this one in here anyways. New Mishnah. If there are 3 brothers, 2 of which married 2 sisters, and the third brother was married to some other woman, and the second brother died childless, so the third brother did Yibum and then married his wife, and then the first husband's wife died, and then the third brother died childless, the first brother cannot marry the sister of his dead wife, as she was forbidden to him at one point during this. The Gemara adds an opinion that based on a verse, if at the time a woman becomes a widow, she's unable to be with her brother-in-law, she can no longer do Yibum with him forever. This is not redundant from our case, because it adds that she's still not permitted to do Yibum if it became permissible during the actual first Yibum situation. This is implied from other cases. New Mishnah. If there were 3 brothers, 2 of which were married to 2 sisters, and the third was married to some other woman, and the middle husband got divorced, and then the third brother died childless, and the second divorced brother does Yibum to marry the third brother's widow, and then he dies childless, this is the case that the co-wives are permitted to marry the remaining brothers. The Gemara clarifies the logic of this case. It's discussed further, and the different opinions argue, again, if this implies the existence of a Zika bond. New Mishnah. With all of the cases discussed in the first Mishnah of the Tractate, if they were done but within a questionable state of betrothal or divorce, their co-wives require Chalitzah and cannot do Yibum. A questionable betrothal would be, for instance, if someone threw the betrothal document to her and it landed close by her, and questionable divorce is where the husband wrote the divorce document himself, but there's no witnesses. Or if there are witnesses, but there's no date on the document, or if there is a date, but there's only one witness. The Gemara says that the implication is that if you throw a divorce document near a woman, it's not questionable. Some say the logic is that prior to the questionable divorce, if the husband had died, she would have been allowed to marry anyone, so it doesn't make sense to prohibit her from a questionable event. This is unlike the betrothal, as that's a stringency. Others argue with that, saying that then this stringent, questionable betrothal will be able to override someone else's proper betrothal. This is argued further. We compare it to a case where a house collapses on someone and his brother's daughter, her co-wife, does Chalitzah and cannot do Yibum, as we don't know who died first. So there's a few answers as to why this is different than divorce. Some say we're more lenient by divorce, as that's a bit more common. Some say because by divorce the woman is right there and you can clearly show she's not allowed to marry the other, along with her co-wife. It's discussed further at length. There's also discussion as to why there's differences between the divorce and betrothal document. Only divorce documents require a date. According to some, it's to prevent the husband profiting off of her fruit after the divorce, and we need to know when the divorce exactly happened for that. Others say it's because you can also betroth someone with money, which you don't mark a date on, and most do that. And if it's to prevent adultery, it wouldn't help, because no matter who's holding onto the document, they could fake the numbers, either the wife to save herself, or the husband to protect his wife. New Mishnah. If there are 3 brothers who are married to 3 unrelated women, and the first brother dies childless, so the second betrothed his widow and then dies, so both of these women must do Chalitzah and cannot do Yibum, as based on the verse, you cannot do Yibum if you have 2 Zika bonds to your brother-in-law. Others say he can do Yibum with one, and do Chalitzah with the other. The Gemara discusses the verse which teaches this. Some add if the second brother who betrothed the widow divorced her before he died, then her co-wife, the second brother's original wife, can do Yibum with the third brother. The divorced betrothed woman cannot, as she might be confused with a case where she's receiving an unspecified divorce document where she cannot do Yibum after. Some say she is actually allowed to marry the third brother as she was properly divorced. New Mishnah. If 2 brothers marry 2 sisters and one brother dies and the other's wife dies, they cannot marry as she was forbidden to him briefly during this period. The Gemara explains that this is pretty redundant redundant. It's just that this was actually taught first. The earlier Mishnah was cited due to its unique ruling and was then put in first, and this was not removed. In the event that the brother-in-law cohabited with his brother's widow while his own wife, her sister, was still alive, there's debate as to what he violated. Some say just as he was with his brother's wife, some say also that he was with his wife's sister. This is debated. It's argued further as to what prohibitions he violated, and this is practically relevant in regards to where he's going to be buried. There's further particular discussion as to what exactly these opinions hold, one of which does not have a more inclusive prohibition principle, and we give a few examples. The disputed points are further explained. They're explained further, and again, the practical difference as to what the violations were by the cases were in regards to where people are buried. New Mishnah. If two men betrothed two women, and at the time of entering the chuppah, they decided to cohabit with the other one's wife, they're both liable for the prohibition against cohabiting with a married woman. If they were brothers, they'd also be liable for cohabiting with your brother's wife. And if the wives were both sisters, they'd both additionally be liable for cohabiting with your wife's sister. And if the women were menstruating, making them ritually impure as a nida, you'd also violate the principle against cohabiting with a nida. Anyways, if this occurs, the women are separated from their husbands for 3 months to watch for pregnancy, and in regards to this principle, if, God forbid, a minor was cohabited with, she does not need to be concerned about watching for pregnancy over the next few months. Also, if they were the daughters of Kohanim, they'd be disqualified from eating Terumah, which is basically produce tithes that can be eaten by Kohanim and their relatives. The Gemara clarifies that this exchange of wives was accidental, and it brings supporting evidence. It debates who the view of this Mishnah is like according to what different people held like by these laws. There's further qualification by this case, such as that the wives have a concern of pregnancy as they cohabited twice, as the first act of cohabitation by a woman cannot make them pregnant, according to one opinion. That's actually disputed, citing many verses in regards to the incident with Tamar, but it's a debated point. There are other particularities mentioned in regards to how and women get pregnant. The remaining points are further discussed. It clarifies the point by the minor girl is an unusual case, hence the lack of an obligation for her to wait 3 months, and there's further disputed opinions in regards to who and in what circumstances does a woman who cohabited and then wants to marry need to wait 3 months after. It also said they cannot eat Terumah if they were the daughters of Kohanim, and it says this means that if they're married to Yisroelim, they cannot eat Terumah from their home. And that's the end of chapter 3. Chapter 4 of Tractate Yevamos covers some additional laws of the Levirate marriage. The Mishnah says there's a law instituted in regards to the Levirate marriage that Yibum should not be done within 90 days of the husband's death to ensure that the wife is not pregnant prior to the marriage. This would mean that Chalitzah cannot be done within this period either. If somebody did end up doing Chalitzah within this period to their brother's widow, and the widow, who as it turned out was actually pregnant, gave birth, as Yibum is not done if the wife has had a child, so the Chalitzah is thereby retroactively invalidated, and they can now legally marry each other's relatives, and she's still allowed to marry a Kohen. If the child was stillborn or similar, the Chalitzah actually was valid, so now they cannot marry each other's relatives, and she cannot marry a Kohen. If they did Yibum and got married, and the woman was then found to have been pregnant and gives birth, they have to get a divorce, and they're liable to bring an offering in the temple. If the baby was stillborn or similar, they can stay married. If there's a question if the child was from the first brother's marriage or a premature child of the new second brother's Yibum marriage, they must divorce, bring an Asham Taloi offering, and the child is legitimate as both marriages were legally valid. The Gemara says a related point, if a brother does Chalitzah with his brother's pregnant widow, and she then miscarried, there's a debate if they need to redo Chalitzah based on if you hold the first Chalitzah was valid. Some say this debate is illogical as to whether we say that the retroactive non-viability of the child works, and some say it's disputed based on a verse. We try to prove from a number of related cases as to which one we hold like. There are further cases brought and disputed, however, in the end we say we hold like the ruling of Reish Lakish, who held that they need to redo Chalitzah. It also says in addition there are some other things we rule in accordance with the opinion of Reish Lakish, such as that when somebody is delineating the property to be given to their child and he wants to adjust the particular amounts, it's permissible if it's done as a gift and you specify that the term gift applies to both recipients. The other thing we rule like Reish Lakish is if a son has a pending inheritance from his still alive father and the son preemptively sells it and then dies while the father is still alive, Reish Lakish says this is a valid sale. Once the father dies as he holds ownership of the rights to property is not the same as owning the property itself. So the father did not actually own the property at the time of sale. Anyways, back to Yibum. We said if you marry somebody through Yibum, she's found to be pregnant, and the baby is stillborn, you can stay married. It says here that others disagree and require a divorce, and there are similar opinions cited. We say from a different source that if a child dies within 30 days, it's considered to have been non-viable, and this is used to discuss some related points. It also says if someone betroths a woman within 3 months of her leaving her first husband and then runs away, some say that they put a ban on him, which basically just means he's treated similar to a mourner. Some say this is sufficient to end the betrothal, which was ruled like by a case where this occurred. In the case where the child could have been born from either husband, it's where the woman gave birth at 7 months and her fetus wasn't noticeable at a third of the days of her pregnancy, so we don't rule with her like we would by majority. There are related points in regards to the uncertain status of some of these children. This is discussed along with some different inheritance disputes that can arise if a child is born within a time frame where it could have been from 2 different husbands. There are a few of such cases brought, and these are discussed further. New Mishnah. If a woman whose husband passed is waiting for her brother-in-law to do Yibum or not with her, and then she inherits property from her father, everybody agrees she can sell it or give it away. If she dies during this period, Beis Shammai says the marriage contract and the inheritance is split between the wife's family and her brother-in-law's family. Beis Hillel says everything stays with whoever owns it, so the marriage contract stays with her brother-in-law and the inheritance stays with her parents. If their brother-in-law did Yibum to marry her, they are considered married in all respects, besides that the marriage contract obligation stays on the estate of her first husband. The Gemara clarifies, according to the sage Ula, the difference between the first case, where everyone agrees that she receives her father's inheritance, is where the first brother died while she was in Arusa, the first stage of marriage, while the disputed case is where he died while she was a Nesua, the completed stage of marriage. Some disagree, specifically Rabbah, and say both cases are where she's a Nesua, having fully completed marriage, but the first case was where she's alive and has a definite claim, unlike the husband's heirs, while in the second case she died, so both claims are uncertain. This is further disputed, and the sage Abaya has his opinion, saying the first case is where she inherited the properties while pending Yibum, and the latter case is where she's still married to her first husband. These opinions argue with one another, and the remaining cases are discussed. New Mishnah. The mitzvah of Yibum falls to the oldest brother. If he's unwilling, you go to the younger brothers. If they're unwilling to do it, you go to the older brother and tell him to do Yibum or Chalitzah. If it was deferred to a minor brother until he comes of age, or to an older brother until he arrives from overseas, or to a deaf, mute, or insane person, this is not allowed, and we force him to decide between Yibum or Chalitzah. The Gemara cites a dispute between if it's preferable to do Yibum with a younger brother or Chalitzah with the older brother. Some say Yibum with the younger brother is better, as the main obligation is with Yibum. Others say that Chalitzah by the older brother is preferable, as they hold the younger brother has no obligation in doing Yibum at all. This is debated between these opinions. Others say that actually both say Yibum from a younger brother is preferable, and the dispute is actually between Chalitzah of an older or younger brother as to which is preferred. Some say it's better if the older brother does it, as he has the obligation. Some say the preference of the older brother is only by Yibum. It just really doesn't matter who does it by Chalitzah, and this is further discussed. There are further related points, including on the validity of certain forms of matzah on Passover. New Mishnah. If someone does Chalitzah with his brother's widow in regards to inheritance, he's treated like all the other brothers. If the dead brother's father is still alive, the inheritance would go to him, unless the other brother did Yibum, in which case the inheritance would go to him. Others say it always goes to the father. The Gemara says that it stated that the brother who did Chalitzah has the same inheritance as his other brothers, as you might have thought that he would have lost his inheritance as he prevented her from ever doing Yibum. We bring sources, and it says we follow the opinion that the inheritance always goes to the father, which is based on a verse which is discussed. New Mishnah. If someone does Chalitzah, they can no longer marry each other's relatives. It lists several examples and says the other brothers can marry into the other family. Also, a man is allowed to marry the co-wife of the woman he did Chalitzah with, but he cannot marry the co-wife of the relative of the woman he did Chalitzah with. The Gemara asks if secondary relatives are also prohibited from marriage in a case where Chalitzah was done. There are a number of proofs brought, but in the end we say from a source that they cannot marry secondary relatives. An additional rule, it says if someone has relations with the co-wife of the woman he did Chalitzah with, the child born from this is illegitimate, which is based off of our discussion. Also, the difference between the woman's co-wife and her relative's co-wife is that the relatives go with the woman to court to get the Chalitzah, so it was ruled that they're treated similar to the woman who received Chalitzah herself. The woman's actual co-wife does not go to court, so they're not forbidden to marry. New Mishnah. If someone does Chalitzah with a widow, and his brother then married her sister, and then dies, they must do Chalitzah and cannot do Yibum. Similarly, if someone divorces their wife and his brother marries her sister and dies childless, she's exempt from Chalitzah and Yibum. If a woman was pending her Yibum with her brother-in-law and then his brother betrothed her sister, some say we should tell them to hold off the completion of their marriage until the Chalitzah is done. Even if the widow dies before they could do Chalitzah, the siblings can still marry each other. If the brother-in-law dies, then the other brother must divorce his new wife and do Chalitzah with the widow. The Gemara asks, we said similarly by the first two cases, where one was pending Yibum and the other was divorced. But the rulings are different. Some say it actually said however, not similarly. In fact, marrying the sister of a divorced wife is biblically prohibited, while marrying the sister of one who did Chalitzah is only rabbinically prohibited. It also mentions that we rule like the latter opinion of the Mishnah. There's a dispute if someone is marrying the sister of a woman who is pending Yibum, and his wife died, can he do Yibum with the widow? Some say yes, as she's considered a woman who was permitted, then forbidden, then re-permitted, so she reverts to her original status. This logic is further debated, and others disagree. New Mishnah, a woman cannot do Chalitzah or Yibum until after 3 months of her husband's passing to see whether she's pregnant. This also applies to all the other previously married women, virgins, non-virgins, divorcee, widows, etc. Others disagree. Rabbi Yehuda says that you don't need to make such a delay after betrothal unless you're from Judea, as there was a concern that people were actually cohabiting with their brides during betrothal. Rabbi Yossi also disagrees, saying any previously married woman can immediately remarry, besides for a widow because she needs to mourn. The Gemara asks, out of concern of pregnancy, it makes sense to not do Yibum during the first 3 months, but why can't you do this after Chalitzah? They're not even marrying. Some suggest this is another refutation of the opinion that you can do Chalitzah while pregnant. Some suggest it's as the child could be born, retroactively removing the necessity for Chalitzah and allowing the woman to marry a Kohen, which would need to be announced, which is debated. And others say it's as the verse seems to imply, that if you cannot do Yibum, you also cannot do Chalitzah during that period either. This is further discussed, along with a related case. A woman by Yibum must wait 3 months, as she cannot get married to her brother-in-law if she was pregnant with child from the prior marriage. But what's the issue with all of the other women from marrying immediately after? So we say, based on a verse, that people shouldn't have ambiguous lineages. There are instances of this given, and some say the issue is that then people might accidentally marry their relatives if they don't know precisely who their father was. She must wait 3 months, and not less, out of concern that the pregnancy was delayed, which is described further. It also says, if you're certain the woman's pregnant, you still need to delay out of worry that if you are intimate while pregnant, it could damage the fetus. But what's the difference between normally cohabiting with your pregnant wife, which is permissible? There are a few answers given, and we say that if she becomes pregnant while nursing, it could mess up her milk, and with your own wife, the husband would pay for nursing alternatives, but there's a concern where it's not the husband's child that he won't provide an alternative, and she'll be too embarrassed to collect her funds from the prior marriage, and her nursing will be damaged and the child will die. These points are further described. It also covers some specific laws of impurity in regards to combs. In regards to waiting 3 months, several sources say you don't need to wait 3 full months, you can marry in the middle of the third. Some disagree. In the end, the ruling is that a nursing woman must wait 24 months before marriage, not including the day the child was born or the day she enters Erusin, the first stage of marriage, and a widow must wait 3 months, not including the day her husband died, and not including the day she enters Erusin. We said a widow must wait to marry, as she's mourning, but why should that prevent marriage if she's allowed to even launder clothing, which based on another discussion by the fast of Tisha B'Av is shown to be more strict? It's discussed. We amend the Mishnah to be talking about the later final stage of marriage, so there's no comparison. This is further debated at length. There are a number of further suggestions offered as to the variance between cases. In the end, we say there's a difference between ancient mourning and current mourning, and also there's a difference between communal mourning and personal mourning, so the cases are really not comparable. New Mishnah. If 4 brothers were married to 4 women and they all died, their older brother is allowed to do Yibum with all of the wives. If one was married to 2 women and he died, doing Yibum or Chalitzah with one of them releases the co-wife from this obligation. If one of the widows was qualified to marry a Kohen and the other was not, If the brother is doing Chalitzah, he should do it with the disqualified one. If he's doing Yibum, he can marry whichever one he wants, obviously assuming he's not a Kohen. The Gemara clarifies the case and disputes a bit in verses which are discussed. The point on doing Chalitzah with the disqualified woman is as Chalitzah disqualifies a woman from marrying a Kohen, so you may as well do it to the woman that's already been disqualified, so as to not cause issues for another woman. New Mishnah, Rabbi Akiva holds that if someone remarried his divorcee after she had remarried, or if you marry a woman you did Chalitzah with, or her relative, you need to divorce, and the child is illegitimate, a mamzer. The rabbis say the child is not a mamzer unless you're marrying the relative of your divorcee, in which case it is. The Gemara suggests that Rabbi Akiva actually also meant the relative of a divorcee, not the relative of a woman you did Chalitzah with, which is supported based on some sources, but they're disputed, and in the end we say, no, he actually meant you're biblically forbidden to marry the relative of a woman you do Chalitzah with, and there are verses brought to prove this. Some say everybody agrees that if someone marries their divorcee, their daughter cannot marry a Kohen, and this includes a later discussed opinion of Rabbi Yeshua. Similarly, it's said, according to some, that everybody agrees that if a Canaanite slave or a non-Jewish person has relations with a Jewish woman, the resulting child is a mamzer. There's some debate as to who this opinion includes, and some disagree, saying their child actually is valid. This is further qualified along with some specific instances. There are a few more cases discussed in this regard. In the end, it says the final ruling is that if a slave or a non-Jewish person have a child with a Jewish woman, the child is still legitimate whether she's married or not. There are a few more related instances brought. There's some discussion on the process as to how a slave would convert. There's further instances on the requirements for conversion in general. Some say it's circumcision and immersion in a mikvah. Some say this immersion can be done on Shabbos, and it's further discussed. It also goes through many of the verses on this topic and further qualifies the exact process of conversion. You have to ask them why they want to and explain that being Jewish is actually extremely difficult with constant hardship and oppression, and if they still want to convert, we accept it, and we teach them the mitzvahs and their laws as to how they'll apply strictly to him now that he's Jewish, and that we don't receive abundance of good or punishment and other points, and if he still wants to convert, he's circumcised, and after he's healed, he immerses in a mikvah, and he's further taught the mitzvahs and obligations of being Jewish, and he's a Jew once he immerses. If it's a woman that's converting, she's immersed by women, and the people teaching the Torah and mitzvahs do it outside. We spend so much time discouraging potential converts, as if converts don't properly abide by the laws of Judaism, it's very problematic, so you gotta make sure people are really serious about joining first. Therefore, the points on this topic, further expounding on the sequence and the reasons. The points and sources are further discussed, and this is all qualified further. New Mishnah. Rabbi Akiva says a mamzer is defined as any child born from a cohabitation which violated a negative commandment. Rabbi Shimon HaTimni says it's a child born of cohabitation that is punishable by kares, which is what we hold like. Rabbi Yeshua says it's a child born of a cohabitation that is punishable by capital punishment from the court, and there are sources which support his view. If someone's wife died, he can marry her sister. If he divorced his wife and then she died, he can marry her sister. If she married someone else after the divorce and then died, he can marry her sister. If the woman you are going to do Yibum with died, you can marry her sister. If he did Chalitzah and then she died, he can marry her sister. If after Chalitzah she married somebody else and then died, you can marry her sister. The Gemara cites verses as sources for the different opinions as to what defines a mamzer. These are discussed along with some discussion as to how the prophet Yeshaya died. He was killed by Menashe, who wanted to kill him, as he felt he had prophesied falsely, so Yeshaya said God's name and was swallowed by a cedar tree, but then Menashe had the tree cut down, killing him. These verses are further spoken on. It also says, some say the last part of the Mishnah is actually redundant, and that's the end of chapter 4. Chapter 5 of Tractate Yevamos deals with some further particularities in regards to the laws of the Levirate marriage, specifically points on betrothal or divorce, which are basically less effective methods of Yibum or Chalitzah in their situation. The Mishnah says, in regards to the laws of Yibum, if the marriage falls between two widows or two brothers, there's no validity to the second divorce document, or to a second betrothal, or to a second Yibum, or to a second Chalitzah. The rabbis say there is actually validity to a second divorce document or to a second betrothal. If a brother-in-law betrothed the widow and then divorces her, he still needs to do Chalitzah. If he betrothed her and then did Chalitzah, he needs to divorce her. If he betrothed her and then did Yibum, that makes a valid marriage. If he divorced her and then betrothed her, he needs to divorce her and do Chalitzah. If he divorced her and did Yibum, he needs to divorce her and do Chalitzah. If he divorced her and did Chalitzah, that's the end of things there. If he did Chalitzah and betrothed, divorced, or did Yibum and then betrothed, divorced, or did Chalitzah, there's no validity to anything after Chalitzah is done. This applies by one brother-in-law and one widow, and also with one brother-in-law and two widows. If he betrothed both, they both require divorce and Chalitzah. If he betrothed one and divorced the other, the betrothed one must be divorced with Chalitzah. If he betrothed one and did Yibum with the other, they both must be divorced and do Chalitzah. If he betrothed one and did Chalitzah with the other, the first must be divorced. If he divorced both, he does Chalitzah to them. If he divorced one and did Yibum with the other, she needs divorce and Chalitzah. If he divorced one and betrothed the other, she needs divorce and Chalitzah. If he divorced one and did Chalitzah with the other, the Chalitzah ends anything further. If he did Chalitzah with both, or did Chalitzah with one and betrothed, divorced, or did Yibum with the other, or he did Yibum with both, or did Yibum with one and betrothed, divorced, or did Chalitzah to the other, the rule is that there's no validity to anything after Chalitzah. This would apply if there's two brother-in-laws and a widow, or two widows and a brother-in-law. If the brother-in-law did Chalitzah with the widow and then betrothed her, divorced her, or did Yibum, there's no validity to anything after Chalitzah, no matter when it's done in the sequence. If he did Yibum and also betrothed her, divorced her, or did Chalitzah, if the Yibum was done first, there's no validity to anything after, but if it was done in the middle or end, there is validity to things after. Rabbi Nechemiah holds that by both Yibum or Chalitzah, no matter where they're done, there's no validity to anything done after. The Gemara discusses the logic of these points. There's further qualification discussed by these particular cases, and the more precise details are all discussed further. There's also debate as to the rabbinic punishment instituted for the violation of some of these principles. Some say lashes, and there's points on how exactly betrothal is done, with either an item worth an amount of money or with a document, the text of which is described. There are additional points. There's some unresolved discussion by particularities of certain divorce documents and further points on the remaining cases. There's also particularities. It's decided that all opinions agree that there is validity to a Chalitzah done with stipulation, but that's not being discussed in our case. There's further discussion on these points. It also goes through which opinions hold which statements from the Mishnah, which is explained in accordance to their particular opinions. And that's the end of Chapter 5. Chapter 6 of Tractate Yevamos continues points on the practice of the Levirate marriage, now on particularities as to the actual performance of the Yibum service. The Mishnah says, if someone cohabited with the woman he was to do a Yibum with, whether on accident, not with this as his intent, under coercion, or willingly, no matter which of them is in any of these situations, it's valid to do Yibum and they're married, and there's no particularities in regards to the manner of cohabitation. These principles of cohabitation would also apply in regards to not being with any of the forbidden listed relatives, or someone disqualified from marriage, like a widow to a Kohen Gadol, or someone who did Chalitzah, or to a divorcee to a Kohen, or otherwise. The Gemara says that even when the male cohabited on accident and the woman did so with improper intents, even though neither intended to do the mitzvah, it's still valid. There's a lot of debate as to what exactly it means to be coerced to cohabit with someone. Some suggest that he was forced, literally. Some say he was sleeping while it occurred. Some say the case is that he fell off a roof and landed on and in a way that resulted in him cohabiting with a woman. These are all disputed. Instead, the suggested case is where he intended to cohabit with his wife, but the other woman was there somehow instead. The case where they were both coerced is where they were literally forced by others to cohabit with each other. And sources are brought which are discussed. There's also debate if you can do Yibum by cohabiting while you're asleep. It's disputed. Some say there's a difference between sleeping and dozing, which is defined. Another ruling, if somebody falls off a roof and lands on a woman cohabiting with her, he's liable to pay her for damage, pain, unemployment, and medical costs, but not for humiliation, as that's only paid if it's intentional. And also, this is not a valid form of Yibum. Also, if someone intended to press themselves against a wall, but the widow somehow got in the way, this is also not a valid form of Yibum. For such a circumstance to somehow work, you have to be pressing yourself against something with actual intent to cohabit with it, and the woman to somehow get in the way for this to be a valid form of Yibum. There's sources listed that even the act of beginning cohabitation is sufficient to do Yibum, which is further discussed. There are more sources for this which are also qualified, and there are several other verses on this topic discussed. It also goes through some times where the Torah specifies the necessity for complete cohabitation, each of which is relevant by a particular situation. There's particular debate as to what precise physical action constitutes the legal beginning of cohabitation. In addition, we said if he cohabits with the woman to any extent, he's acquired her for Yibum. Some interpret this to mean that he's fully properly done Yibum. Others say it means that this isn't a fully proper method of Yibum, and he's acquired her in accordance to what the verse references, which is to inherit his brother's estate, and to free her from the attachment of Yibum. This is for the qualified, along with some specific cases in regards to eating Terumah in regards to the laws of marriage. There's also points on the continued permissibility of a woman to her husband if she cohabits with somebody else. If it was consensual, meaning it was effectively adultery, she can no longer be with her husband. If it was not consensual, she can still be with her husband, but it implies that if the husband was a Kohen, they can no longer be married. This is further debated. New Mishnah. If a widow impermissibly married a Kohen Gadol, or a divorcee, or a woman who did Chalitzah impermissibly married a Kohen from the first stage of marriage, Erosin, they cannot eat Terumah, which is food tithes that can be eaten by Kohanim and their relatives. Others disagree and say that they can. If these women were then widowed or divorced from these marriages, if this occurred after the final stage of marriage, Nisuin, they are disqualified from marrying a Kohen. If it was before, by the stage of Erosin, they are still permitted to marry a Kohen. The Gemara debates the logic of the opinion that says they can eat the Terumah. There's a specific case brought. If a Kohen with damaged genitals betrothed a woman, this is a dispute, as according to our opinions, who said a woman awaiting biblically forbidden cohabitation cannot eat Terumah, while the others say she can. It's explained that the cases are comparable. Abaya says as she can eat Terumah if he's not cohabiting with her after becoming injured, and Rava says as there are others who are now allowed to eat Terumah, being their slave. Abaya did not hold like Rava here, as he says you can derive laws of matrimonial acquisition from other laws of matrimonial acquisition, and not from acquisition of slaves. Rava would disagree with Abaya, as by the case of the injury, she was eating Terumah before he got injured. This is further debated. There's also a question if a maimed Kohen can marry the daughters of a convert. It's disputed who this question was asked in accordance with. It said she's allowed to marry a Kohen, but is not fully considered to be a part of the Jewish people, so could eat Terumah if married to a Kohen. With all the cases where a Kohen marries someone forbidden to her, there's dispute if the chuppah, the formal entry of the bride into the husband's domain to complete the marriage, if this has any legal significance. Shmuel and Rav hold that, as discussed by a later case, if, God forbid, a Kohen marries a girl 3 years or younger, she still cannot be legally cohabited with, and cannot legally do chuppah, unlike a girl above that age where cohabitation would be considered legally significant, although it goes without saying that that's not something that should be done ever. There's further dispute on other points in regards to eating Terumah by the laws of marriage. There's additional particularities discussed in another case, in the event that a Kohen Gadol betrothed a minor to wait until she became of age, a bogeres, as it's called, before finalizing the marriage. There's dispute if this is legally permissible, and it implies no, but this is not comparable to the case of a widow, as the difference between cases is that the widow does not physically change between the stages of marriage. New Mishnah. A Kohen Gadol can only marry a virgin, so he cannot marry a widow, no matter if she was widowed during the marriage stages of Erosin or Nisuin, and there's debate if he can marry a bogeres. He also may not marry a woman who is not a virgin due to being injured by a piece of wood. The Gemara cites verses that show he can't marry the widows. The dispute if she can marry a bogeres is in regards to dispute over the implication of a verse, in regards to particularities as to the level of virginity the woman must have. There's dispute if this is still permissible if the woman has had relations before, albeit not in the typical manner. There are additional points on this. It mentions if a woman was violated by an animal, this does not render her unfit to marry a Kohen, and that a Kohen Gadol cannot marry a woman that he had violated or consensually cohabited with premaritally. And some say he does need to divorce her if they marry, although he wouldn't need to pay the typical fine for consensually cohabiting with her premaritally. Others disagree, and it's discussed. This is all further qualified. There are a few specific instances. It mentions we hold like the opinion that says a Kohen can marry a woman who had converted while she was a child younger than 3, which is further discussed. There are additional points. New Mishnah. If a Kohen started marrying a woman, the first stage, Erosin, and then became a Kohen Gadol before completing the marriage, he can still marry her. It mentions an instance where this occurred. If a woman was pending Yibum with her brother-in-law, a Kohen, who then was appointed to be a Kohen Gadol, even if he betrothed her beforehand, he cannot marry her. The Gemara cites sources for these points and discusses the instance where this occurred. New Mishnah. If a Kohen Gadol's brother died, he does Chalitzah with the widow, not Yibum. The Gemara said this would apply if the widow had been fully married or was still in the first stage, even though if she's only an Erosa, she hadn't cohabited yet out of concern that he might fulfill his obligation of cohabiting with her to the Yibum, and then might do it a second time, which is forbidden as she's a widow. New Mishnah, a Kohen cannot marry an Ailonis, a woman with a condition that causes her to exhibit physical male characteristics, probably Turner syndrome or something similar, unless he already had a wife or children. Others say he still can't marry her, even if he has a wife or kids, as the marriage is forbidden by the Torah, which says he can't marry a Zona, which he defines as someone who can't have kids. Others define it as a female convert, a freed slave woman, or someone who had cohabited impermissibly. The Gemara further expounds on the logic of these opinions. There are other opinions as to what exactly constitutes a zona. Some say it's an adulteress, some say it's a woman who is willing to cohabit with any person, some say it's someone who cohabits with their husband after being accused of adultery, some say it's an ailonis, some say it's a female convert, or a freed slave woman, or a woman who had cohabited impermissibly. Others say it's an unmarried woman who cohabited with an unmarried man without intent to marry. It also discusses the impermissibility of a Kohen to marry a minor, which is discussed, and further additional points. New Mishnah, a man is not allowed to abstain from procreation unless he already has children. Beis Shammai says he must have 2 male children. Beis Hillel says he must have a male and a female, as the verse says he created them male and female. The Gemara says if he has children, he's not obligated to procreate if he has children, but he is still obligated to be married. In such a case, some say you'd be allowed to marry a woman who can't have children, and there's a practical difference by selling a Torah scroll to marry a woman. It's only allowed if he does not yet have children. The explanation of the opinions of Beis Shammai and Beis Hillel in regards to the children you'd need to have to fulfill your obligation are discussed. Moshe abstained from procreation after having 2 sons, but that's not a viable proof, as that was one of the 3 things Moshe did based off his own logic, that he permanently separated from his wife. As he always spoke with the divine presence, he broke the 2 tablets based on the logic that an apostate can't give the paschal offering, so for sure they shouldn't be able to receive the whole Torah, which God actually commended, and he also added a day of abstinence to the Jewish people before accepting the Torah based on the verse, including the day that the command was given. This is further discussed. It mentions if a person converted, so there's a dispute if his children from before the conversion fulfill his obligation to have children. Some say yes, as he has children. Some say no, as conversion legally resets all of your familial relationships. There's a similar argument if a convert can have a firstborn son from before his conversion in regards to the laws of inheritance. We need both of these cases to be brought, as some say non-Jewish people are also obligated in this requirement to have children. This for the discussion on this topic. There's debate if 2 grandchildren from a single child is sufficient to fulfill this obligation, based on if grandchildren are regarded as children, which is a disputed point. Some say a person should never abstain from having children. Similarly, Rabbi Akiva said a person should never abstain from learning Torah and having students, no matter his age, which is seen from the fact that Rabbi Akiva had 12,000 pairs of students, and they all died from a plague of diphtheria between Passover and Shavuos, because they didn't treat each other with respect. So he only had 5 students left: Rabbi Meir, Rabbi Yehuda, Rabbi Yossi, Rabbi Shimon, and Rabbi Elazar ben Shammua, and he continued to teach them from there. A side point, the day that this plague ended, and also the day his student, Rabbi Shimon bar Yochai, passed, have been instituted as a holiday, the holiday of Lag BaOmer. Anyways, we hold like this opinion that a person should never abstain from having children. There are other miscellaneous points on the high importance of being married, saying without it a man has no Torah or peace or similar, and it speaks about the conjugal obligation of a husband to his wife. There's a lot more on this, several other points on the importance of choosing a good partner, an expansion on a few verses, and good business and agricultural practices. It also speaks on a few instances of individuals whose wives would aggravate them, and related points. There's a lot more instances on marrying a good wife and examples as to what constitutes a not good one, and quotes from other texts more on the importance of marrying a good woman. There are additional points on this. New Mishnah, if a man married a woman and stayed with her for 10 years and she did not have children, he must marry a new wife. If he divorced her, she can marry someone else and try again. If she miscarried, the 10 years are recounted from the miscarriage. The Gemara discusses based on this how the forefathers, Abraham and Yitzchak, stayed married to their wives as they were infertile for several years. Also, it mentions that God answered Yitzchak's prayer even though both him and his wife were answered, as Yitzchak was a righteous man, the son of a righteous man. It also says that the forefathers were infertile, as God desires the prayers of the righteous. Some say it was an exceptionally great miracle that Abraham and his wife Sarah had a child based on verses. Some say that both of them were tumtumim, with covered reproductive organs. Some say Sarah didn't even have a uterus. Some say the 10-year marriage limit without children is actually reduced to 2.5 years, as lifespans were shorter in later generations. Some say it's 3 years, as discussed. Some say if they don't have a child after this period, while she can remarry, she can't remarry a third time. There's further discussion. Some say she could remarry for the third time someone who already has children, and if she marries someone who does not have children, she must divorce without receiving the stipulated payment from her marriage contract. There's further qualification. Some say if a woman miscarried 3 times, she must be divorced, and there's a dispute as to what to do if she miscarried twice and claims she miscarried a third time. It's ruled that we believe her, as she wouldn't want to be established as a woman who frequently miscarried. New Mishnah. It's an obligation to be fruitful and multiply, which applies to men, and some say it also applies to women. The Gemara brings and discusses the verses as source. It also says a ruling, the same way it's a mitzvah to rebuke someone if they'll accept it, it's also a mitzvah to not rebuke somebody if they won't accept it. Some say it's even a mitzvah to not tell the truth if it'll keep the peace between people, as learned from the incident with Yosef and his brothers, and Shmuel secretly anointing David. There's dispute as to who we follow in regards to if it's also a woman who has the obligation to have children. This is further discussed. It concludes that women are exempt from this obligation, and it gives an instance of a case where the rabbis forced a man to fully free his half-slave so she could marry a free man, but that was only done as she was frequently cohabiting with other men. And that's the end of chapter 6. Chapter 7 of Tractate Yevamos further goes through additional laws of the Levirate marriage. The Mishnah says if a widow is married to a Kohen Gadol, which is impermissible, or a divorcee, or a woman who did Chalitzah, is married to a Kohen, the woman's property, which has the designation of either Son Barzel, an item of assessed value, which is declared to the status, and is returned to the woman in the event of the marriage's termination, or the designation of Milog, which is basically everything else, and if the marriage terminates, she gets the value of the item as is, meaning not accounting for its original amount. Anyways, if she had slaves, if they were designated as Milog, they cannot eat Terumah, and if they die or go up in value, it's her loss or gain. If they're designated as Son Barzel, they can eat Terumah, and if they die or go up in value, the value goes to the husband. If the daughter of a Yisroel marries a Kohen and has slaves of either sort, they can eat Terumah. If the daughter of a Kohen marries a non-Kohen and had slaves of either sort, they cannot eat Terumah. The Gemara debates this point from a source which implies that the slave of the wife of a Kohen can also eat Terumah, regardless of the status of the wife, but this is different here as it's a widow who can't eat Terumah herself, so therefore can't allow others to, which is a bit of a general rule. Others disagree and say that actually they can eat Terumah. The point is that they want to cause issues, so the widow divorces him, therefore, as it's a forbidden marriage. Others say it's forbidden out of concern that she'll continue giving them Terumah after the husband had died, and this applies by all widows married to a Kohen Gadol. It further defines the different property statuses of Milog and Son Barzel, which are further discussed, and there are some additional points on this. New Mishnah. Rabbi Yossi says, if a Yisrael's daughter marries a Kohen and the Kohen dies, leaving her pregnant, her Son Barzel slaves can't eat Terumah due to the fetus in the womb, which disqualifies them from eating the Terumah. The rabbis say, by that logic, that would also apply to a Kohen's daughter too. The Gemara asks why exactly the fetus disqualifies them from eating Terumah, possibly as it's a non-Kohen while it's a fetus, so there's no Kohen to make the Terumah permissible. Possibly because an unborn Kohen can't entitle others to eat Terumah. There's a practical difference if the fetus is a girl. There's debate as to which one is the issue. Some say if there are other children besides for the fetus, slaves can eat Terumah in their account, or possibly from the father's brothers, or even his other relatives. This topic is further discussed. Some say a daughter entitles others to eat Terumah along with a son, unlike by just a son in a case where it's a meager estate, which is qualified. New Mishnah. A fetus, somebody requiring Yibum, somebody going through betrothal, a deaf-mute, and a boy 9 years and a day old disqualify others from eating Terumah, but cannot entitle others to eat Terumah on their account. This would also apply if there's a doubt if the boy is 9 years and a day old, or if there's a doubt if the betrothed boy has fully reached the necessary stage of physical development. If a house fell on him and his brother's daughter, and you don't know which died first, her co-wife does Chalitzah and cannot do Yibum. The Gemara qualifies points on these laws. The explanation is provided for these instances, and specifics on these situations are discussed. It also speaks on sources for these points from Scripture. There's further discussion on other prohibited unions which prohibit a woman, and disputes on second-generation Egyptians or Edomites and similar. New Mishnah, someone who violates or seduces a woman or is deranged, they do not disqualify the woman they cohabited with from eating Terumah, and they do not get to eat Terumah themselves. If they are unfit to marry a Jewish person, they would disqualify her. It gives specific instances of several of these cases. The Gemara further discusses these points, and it brings verses as sources, and it goes through some of the specific case instances and qualifies them. And that's the end of chapter 7. Chapter 8 of Tractate Yevamos covers additional laws on the Levirate marriage, and also on the permissibility of people connected to Kohanim eating Terumah, which is produce tithes that are given to Kohanim. The Mishnah says an uncircumcised person and someone ritually impure cannot eat Terumah, but their wives and slaves can. If a Kohen had injured genitals, his slaves can eat Terumah, but his wife cannot. If he had not cohabited with his wife after his genitals had gotten injured, his wife can eat Terumah. It gives definition as to what exactly constitutes a genital injury. The Gemara cites the scriptural source for these rulings, which are discussed as to how this is derived from their words. It also is learned from a comparison to a verse about the Paschal offering, which is further qualified in regards to how we know an uncircumcised individual cannot eat Terumah. There are further verses on this topic discussed. It also speaks on specific cases of a lack of circumcision disqualifying individuals from the Paschal offering, and also some say that they can still be purified from ritual impurity. There are other particular verses mentioned on specifics with the practice of circumcision. Some say the Jewish people born in the desert were not circumcised until they crossed the Jordan River and entered Israel, as they were tired from the journey, or because the north wind didn't blow for them, possibly as God was rebuking them, possibly so the clouds of glory wouldn't disperse. Based on this, some say not to circumcise or draw blood on a cloudy or extremely windy day, but it says now that everybody does it, so God will protect them. There are issues cited with someone who is circumcised, but his skin is in a way that he looks uncircumcised, with such an individual eating Terumah. Some say he can't, others dispute this, and sources are cited. This is further discussed, and it also debates if an uncircumcised person is allowed to perform the water sprinkling for ritual impurity on somebody else. It's disputed. This is discussed. It's debated if an uncircumcised person can eat Ma'aser Sheni tithes based on how it's compared to the Paschal offering. There's also a dispute if a mourner is permitted to eat Ma'aser Sheni tithes or Bikurim, the first fruit tithes, and the opinions that say you can or can't cite verses which imply like their opinions, and this whole thing is further discussed. This whole topic in regards to a lack of circumcision or a lack of proper circumcision as to who can eat Ma'aser Sheni tithes is further qualified with several proofs from a bunch of different sources, but it also brings the verse sources that an impure person cannot eat Terumah. These verses are further discussed. This is all explained further, and it also argues over who the source is for the point against a Kohen with injured genitals from his wife eating Terumah, and it further qualifies what exactly constitutes an injured genital. There are several possible different forms of injuries listed in detail, be they punctures or cuts, and how severe the wounds need to be, etc. There are a few other particularities that constitute a genital injury. It also says we don't hold like the opinion that if somebody urinates from two places, he's unfit to marry, and it also says if a person and a woman cohabit without intent to marry, this constitutes the woman as a zona. But if the woman had relations with another woman, this does not legally constitute as cohabitation, so they're not rendered a zona, but it says it's still generally improper. New Mishnah, somebody with injured genitals can still marry a convert or a freed slave woman, but they can't marry a regular Jewish woman. This is based on the verse, one with wounded or crushed testicles or whose member is severed may not enter the congregation of God. The Gemara debates by this if a Kohen is allowed to marry these women, as he normally cannot, but perhaps now he can due to his unique injured state. We bring a proof that he would be allowed to, as his state of sanctity is removed after this injury. It also debates if the prohibition against intermarriage applies by a legally binding marriage, which is debated based on some verses on King Shlomo with the Pharaoh's daughter who he married. There's further discussion by these points. New Mishnah, an Ammonite or a Moabite convert and their descendants are not permitted to marry Jewish people. Female Ammonite and Moabite converts can. An Egyptian and Edomite convert can't marry in for 3 generations, both for male and female. Rabbi Shimon allows the marriage immediately, which is based on a comparison to the others, which some doubt, but he says it's also just a law passed down from tradition. The Gemara cites verses as a source for these rulings, and it discusses some related verses about David and King Shaul. There are several other verses on this discussed and expounded on about King David, and further points in the source for the prohibition of the daughter of Ammonite converts from marrying a Kohen, which is compared to a Kohen Gadol cohabiting with a widow, along with other related points. And These topics are all discussed further. There are also related verses brought, and some other rulings, like if a second-generation Egyptian convert married a first-generation female Egyptian convert, their son is classified as a third-generation Egyptian convert, which implies we go according to the father, but other sources imply we go like the mother, but that source is an exception, as that's where the mother was a slave woman, which had unique laws. This is further debated, and there are sources that say it does actually go in accordance with the mother. There are other opinions on this discussed. Some say if they've converted, you follow the more blemished of the two, meaning if a male Ammonite convert married a female Egyptian convert, if the child is male, he goes after his Ammonite father. If it's a female, she goes after her Egyptian mother. New Mishnah. A mamzer, a child born from a forbidden cohabitation, and the Chivite inhabitants of Gibeon that tricked Yahushua into being converted during the conquering of Israel as described in the books of prophets, are forever not allowed to marry into the Jewish people, both men and women. The Gemara says a dissenting opinion that a female mamzer is allowed to marry into the Jewish people after 10 generations, and it brings a source. Some say this is not even an issue, as mamzerim are said to not have their line continue for any generations if they're not publicly known about. If only some know about their status, it's said that their line will continue for 3 generations. There's an incident mentioned where a sage publicly declared a man as a mamzer so that way God would allow him to live. The verses regarding the Gibeonites are all discussed, and there are several other verses related. It also says, eventually the sages decided to release those people from the servitude they had sworn to from the times of Yahushua, which they did, and also the altar in the temple had no ownership over them, as this was after the destruction of the temple. New Mishnah. A saris, a sterile man, either from castration or a disorder, is said to be allowed to do Chalitzah and have Chalitzah performed after his death, but then they also say that they can't, which is seemingly contradictory, so there are some explanations. Some say this means that a Saris Adam, a sterile male from castration, is allowed to do Chalitzah, as there was a period where he was viable. A Saris Chama, a sterile male from birth from a disorder, would not be allowed to do Chalitzah because he was never viable. Others say it's the exact opposite. A Saris Chama can do Chalitzah as he has the possibility of a cure, unlike by a Saris Adam, as he's castrated. There's an incident which implies like the first opinion. Anyways, a saris, or an ilonis, a woman who does not physically mature in a typical manner, do not do chalitza or yibum. If a saris did do chalitza or yibum, he hasn't really done anything, so the woman can still marry a Kohen. If he cohabited with her, she cannot marry a Kohen, as this is an illicit relation. Or if brothers did chalitza or yibum with an ilonis, it doesn't do anything, and she's not disqualified from marrying a Kohen, unless they cohabited with her, in which case that's illicit relations. The Gemara says that actually the first opinion would allow the Saris Adam to do Chalitza and Yibum, based on his other logics of the case, and we bring sources. It also gives definition as to these Saris deformities, and say that they can be caused by the mother drinking beer while he's a fetus, and other points. These particularities are further discussed. It also further qualifies as to what exactly constitutes these unique disorders, and this is all further discussed. New Mishnah. A Saris Chama, a sterile male who was born that way, who is a Kohen, who was married to the daughter of a Yisroel, she can still eat Terumah. Some say a Tumtum, a person with a genital condition that causes him to be of indeterminate gender due to excess flesh covering the region, his wife can eat Terumah. Some say if the flesh is torn and he's found to be a male, he should not do Chalitza because he is now considered a Saris. An androgynous, somebody with both male and female genitals, can marry a woman, but not a man. Some say that if a man cohabits with an androgynous, the same punishment applies as a man cohabiting with another man. The Gemara explains that it needed to say a Saris Chama Cohen's wife is allowed to eat Terumah, even though he cannot have children. It says an androgynous Cohen's wife can eat Terumah, but some say she can't eat the breast and thigh of a Kachei Kalim offering, which are offerings of greater holiness. Others disagree and say she could. It's disputed, and this is all further discussed. It's spoken on a bit further and debated as to who exactly we hold like. It also disputes as to what exactly an androgynous constitutes. Some say they're considered a male, some disagree. It's debated if their marriage is a fully legally acceptable one. This is discussed along with some related points. It also goes through some points on grafting, what the gender of a tumtum whose flesh covering is torn open is considered, which is debated in particularities as to the prohibition against a man cohabiting with an androgynous, where it brings verses as a source. It also says the opinion that holds that a man cohabiting with an androgynous is the same as a male cohabiting with another male does not necessarily hold that an androgynous is always considered to be legally a male, which is relevant by several other laws. It also mentions an incident where they taught the teaching that a male can't cohabit with an androgynous. And that's the end of chapter 8. Chapter 9 of Tractate Yevamos continues discussing the various laws of the Levirate marriage. The first Mishnah says there are some women who fall into a category where they're permitted to be with their husbands, but forbidden to do Yibum, the Levirate marriage. Things like a Kohen married to a widow whose brother is a Kohen Gadol, a regular couple where the husband's brother is a mamzer, an illegitimate person, a female mamzer married to a mamzer whose brother is a regular person, and others. There are also women who can be permitted to do Yibum, but not to be with their husband. A Kohen Gadol betrothed to a widow, where the brother is a regular Kohen, a regular man who married a female mamzer, and his brother is also a mamzer, and that kind of thing. There are some cases where the marriage and the Yibum is forbidden. A Kohen Gadol married to a widow, and the brother is also a Kohen Gadol, or a Kohen. A regular husband marrying a female mamzer, and his brother is also a regular male, etc. And there are also more typical cases where both would be permitted. If the woman is rabbinically forbidden to be with the husband due to being a secondary relative, but not his brother, she can't be with the husband, but can do Yibum with the brother. Or if she's rabbinically forbidden to the brother with Yibum, but not to her husband, she can be with the husband, but not do Yibum. If she's rabbinically forbidden to both, she can be with neither. If such a rabbinically impermissible marriage occurs, she doesn't get the rights to the marriage contract, produce, sustenance, or old garments, which are all things that a husband is obligated to sustain his wife with. Their child is legitimate, and they must still divorce. If it was a biblically forbidden marriage, a widow marrying a Kohen Gadol, a divorcee marrying a Kohen, a mamzer marrying a regular person, there is a valid marriage contract. The Gemara asks, it says the case of a Kohen who's married to a widow, and whose brother is a Kohen Gadol. It says married, not betrothed. There are a few answers proposed why. Some say if it's just betrothal, it'll be a positive commandment to do Yibum, and only one negative commandment. But that doesn't work, as we already know the positive commandment does not override the single negative commandment from all the other cases discussed. We try to suggest it because it says married by the later case, but that doesn't work because the other later case also says betrothed. So we say it's actually because the very next case of the Mishnah says married, which is necessary for its case. So does this one. Another question on the wording of this case, it says he married a widow. Why does it need to be a widow if she'll become a widow once her husband dies anyways? Again, similar answers are suggested and rejected, and we say it's because the later part of the Mishnah said the case by a widow, so it said it by this one also. It also rediscusses some points from an earlier chapter on marrying the descendants of Egyptian converts and clarifies some points. This is discussed and mentions that the daughters of Kohanim are allowed to marry disqualified men, like a Chalol, the child of a Kohen who married a divorcee. Sources are discussed. There's a question, if a woman is a rabbinically forbidden secondary relative to the husband, but not to his brother, if there's a valid marriage contract with the brother, if they end up doing Yibum, the Levirate marriage, and we say no. Although, generally, if she doesn't have a marriage contract from her husband and he dies, she gets one from her new husband if she does Yibum. We said a biblically forbidden marriage, like a widow to a Kohen Gadol, she still does get a marriage contract. Some say she nevertheless doesn't have the rights to sustenance until after the husband's death. A different source says in such a marriage, she gets the marriage contract, produce, sustenance, and old garments, but she and her child are disqualified and they're obligated to divorce. This is unlike a rabbinically forbidden marriage by secondary relatives, where you don't get the marriage contract or any of the other provisions, but she and her child are still legitimate, although they do still have to divorce. The reason the marriage contract and all the other provisions are given by the biblically forbidden marriage is because there they'll end it, as it's more strictly forbidden, but they need encouragement to divorce by the rabbinically forbidden marriage, so those provisions are all not allowed. Some say it's because there the laws themselves are rabbinic, which need additional support to be enforced. Others say by the biblically forbidden marriage, the man is persuading the woman to marry him, but by the rabbinically forbidden one, it's the woman persuading the man, so she's penalized. The sources for these teachings are clarified. It also brings a few practical differences that would result between these different opinions. For instance, a confirmed sota, a woman who definitely committed adultery. The one who says the marriage contract is given if she's biblically forbidden, but the one who says if the woman convinces the husband to be with her is not given the contract, that would not be given here. New Mishnah, if the daughter of a Yisroel is betrothed to a Kohen, or is pregnant from a Kohen, or is pending Yibum to a Kohen, or these by the daughter of a Kohen to a Yisroel, she may not eat Terumah. If it was with a Levi, she may not eat Meiser. If it was the daughter of a Levi betrothed, pregnant, or pending Yibum by a Kohen, or the daughter of a Kohen to a Levi, she cannot eat Terumah or Meiser. The Gemara says this is like the minority opinion that holds Ma'aser Rishon cannot be eaten by Yisroelim, hence why it's forbidden in the first case. His sources for this are brought and discussed, however, the explanation is actually rejected, as the third case says the Ma'aser is forbidden to a Levite woman betrothed to a Kohen. Some say this just means that we don't distribute the Meiser to her at the granary out of concern that she'll be in seclusion with another man. Some say it's because she's a divorcee and might keep renewing Meiser there after the divorce. But that's difficult, as a divorced female Levite can still eat Meiser, but we say it's just done as a precautionary measure, as it's not allowed by Yisroel, who divorced a Kohen. It also specified betrothed, even though this would still apply while it's married, because the first part of the Mishnah said betrothed. It further argues many opinions in regards to Kohanim or Levi'im eating Meiser. Verses are also cited. New Mishnah. If the daughter of Yisroel marries a Kohen, she can eat Terumah. If the Kohen dies, but she has a son, she can eat Terumah. If she then marries a Levi, she can eat Meiser, but not Terumah. If the Levi dies and she has a son from him, she can eat just Meiser. If she marries a Yisroel, she can't eat Terumah or Meiser. If the Yisroel dies and she has a son, she can't eat Terumah or Meiser. If the Yisroel son dies, she can eat Meiser from the Levi son. If the Levi son dies, she cannot eat Terumah again. If the Kohen son dies, she can't eat Terumah or Meiser. If the daughter of a Kohen married a Yisroel, she can't eat Terumah. If he dies, leaving a son, she still can't eat Terumah. If she marries a Levi, she can eat Meiser. If he dies, leaving a son, she can eat Meiser. If she marries a Kohen, she can again eat Terumah. If he dies, leaving a son, she can still eat Terumah. If the Kohen son dies, she can now only eat the Meiser. If the Levi son dies, she cannot eat Meiser. And if her Yisroel son dies, then she goes back to her father's house. As the verse says, she shall return to her father's house as in her youth. She may eat from the bread of her father. The Gemara clarifies additional points on several of these rulings. Some say when she returns to her father's house, while she can go back to eating Terumah, she cannot eat from the portions of the Shalomim offering, and sources are brought and discussed, and the remaining points are also qualified. And there's some additional clarification on some unique cases that are brought, and additional discussion and questions. And that's the end of Chapter 9. Chapter 10 of Tractate Yevamos continues discussing the laws of marriage. The first Mishnah says a woman whose husband went overseas and she was told that he died, so she remarried, and then the husband, as it turns out, had not actually died and returns. She needs to divorce both husbands and has no claim to the marriage contract, to the rights of produce, sustenance, or old garments from either husband. If she did take such payments, she needs to return them. Any child born from either husband is a mamzer, an illegitimate child, and if they are Kohanim, they are not permitted to become ritually impure from contact with her corpse. Neither husband is entitled to her earnings, nor are they authorized to annul her vows. If she's not a Kohen or a Levi, she can no longer marry a Kohen. If she's a Levi, she can't eat Meiser. If she's a Kohen, she cannot eat Terumah. Neither husband's heirs inherit her marriage contract, and if either die childless, their brothers do Chalitzah, not Yibum. Some have particular disagreement. Reb Yossi says her marriage contract is valid with her first husband. Reb Eliezer says the first husband is entitled to her earnings and can annul her vows. Rabbi Shimon says the first husband can do Yibum or Chalitzah and exempt her co-wife from doing either. And also their child is not a mamzer, so the child is legitimate. Now, all of this was if a single witness reported the husband's death, which is a special exception to allow women to remarry easier. If there were two witnesses that testified to the husband's death and she remarries, she's allowed to continue to be with her first husband if he reappears. If she had remarried from one witness, she needs to divorce both, and she's exempt from bringing a chatas offering due to the power of the court. If she had remarried from two witnesses, she needs to divorce her new husband and is liable to a chatas offering. If she was told that her husband died based on one witness, and then she just went and immorally cohabited with another man, and then found out that her husband was actually alive, she's liable to bring a chatas offering, as she was only allowed to remarry. The Gemara says, although the wording in the first case says they testified, it refers to a single person's testimony based on the later part of the Mishnah, referring specifically to two witnesses in comparison to this part. Normally, we basically always require two witnesses for everything, according to Jewish law. One of the only exceptions is in a case like this, where a woman's husband vanishes It leaves her in stasis, essentially, without her husband, but unable to remarry, as she's not certain if he's dead or not. So in such a situation, there's a leniency to believe a single witness who testifies that her husband died to allow her to therefore remarry. This is also learned from other sources too. Another thing, a single witness is said to be believed by if a single witness tells a person that that individual inadvertently ate chalev, forbidden fats. If that man doesn't dispute it, then he's liable to bring a chatas offering, and we bring sources which are disputed. There's further argument on these sources, and in the end it concedes that a single witness is actually not believed by an established prohibition. However, by the woman remarrying, that's permissible as it's a rabbinic institution. If she remarried from the testimony of one witness and the husband comes back, we said she needs to divorce both of them. Some say if there were two witnesses, she doesn't need to divorce her husband, but that's only where she cannot recognize the old husband and the witnesses also testify that it's the same man. It's still debated as to how she's allowed to remain married to the second husband. Some say it's where there were two arguing sets of witnesses who came as to whether her husband died, and then after she remarried, wherein this ruling was stated to disagree with an opinion that says she would need to leave her husband. Or some say it's where she remarried and then the second witnesses came, that she can stay married, and if she married after both witnesses came, she can't remarry, which actually means she's agreeing with the second opinion. This is for the disputed. Some say that actually it just means she can just stay with her first original husband. Regarding the case of a single witness, some say she only needs to leave the second husband if she recognizes that the returning husband was her original husband. If she says that's not actually him, she wouldn't need to divorce her new husband. The case is clarified to be dealing with two witnesses who say it was the original husband, but they would be normally disqualified, which is further discussed. She needs to divorce also the second husband, even though, as it turns out, her first husband was still alive. So it was effectively just adultery. However, it's a rabbinic institution, so that way people watching who don't know the situation won't think that she just left her husband without a valid marriage contract, and this is for discuss. There's qualification by some related cases. Anyways, we said in the case that she doesn't get her marriage contract. This is because she did adultery effectively and must be divorced, and the whole purpose of a marriage contract is to discourage divorce. The other rights listed have the same status as the marriage contract, and the remaining points are also clarified. It also brings sources for many of these points, and there are additional proofs cited and discussed also for some additional points, like in regards to certain services in the temple. This is all discussed further, along with points on the source for her Kohen children not being allowed to become impure for her corpse. We also said her husbands aren't entitled to her property or earnings, or to revoke her vows, which is something normally given to promote a happier relationship, but here we want them to divorce, so we don't allow such things. The remaining prohibitions are also explained. We also said there were three opinions who disagree with particular parts of the prohibitions. Some say that each later opinion agrees with the prior one, but the initial opinions disagree with the later ones due to their opinions on the severity of the prohibition. The last actually allowing cohabitation with Yibum, the second allowing monetary earnings, and the first allows only the marriage contract, which is collected even as the marriage ends. Others say it's the exact opposite. The initial opinions agree with the later ones, and the later opinions disagree with the initial ones. The marriage contract is taken from the husband and is the most strict. The second is more lenient, where it's the wife's earnings to the husband, and the third is cohabitation with Yibum, which would apply even after the husband's death. We also said that if she remarried on the basis of two witnesses, she can return to her original husband if he's found, and it's disputed if we hold like this. This opinion is argued on further from several different sources. It remains unresolved, and practically in a case, we go like the strict opinion. So if a woman remarries based on a testimony and her husband returns, no matter if it was with one or two witnesses, she has all of those listed penalties apply. If she remarries and there's just a rumor that the husband was still alive, she's not penalized. This means that the rumor is considered to be as if it came about after she married. Some disagree with the Mishnah's statement that she needs to divorce both husbands after the testimony of a single witness. There are sources brought. At the end, we discussed immoral cohabitation. Some say this refers to cohabitation outside of marriage. Some say this refers to a widow marrying a Kohen Gadol, or a divorcee marrying a Kohen, or similar. The first opinion would agree with the second, but not vice versa. Sources are brought. New Mishnah: if a woman's husband and child went overseas, and she was informed that first her husband died and then her son, so she married somebody else, and then after was told it was the inverse, that her son died first, thus requiring her to actually have done Yibum, she now needs to leave her new husband, and the child, either conceived before or after this occurred, is a mamzer. If they informed her that her husband had died first, so she did Yibum, and then she's informed that actually her husband had passed first, she needs to divorce, and the child, either conceived before or after this occurred, is a mamzer. If she was informed that her husband died, so she remarried, and was then told that your husband was actually alive when you had remarried, but died after, she must divorce, and the child conceived before this occurred is a mamzer, and if it's after, it's legitimate. If she was told that her husband died, so she betrothed somebody else, and then her husband came back, she can go back to him. If the second husband gave her a divorce document, she'd still be allowed to marry a Kohen. This is learned from the verse, and nor shall they take in marriage a woman divorced from her husband, meaning it had to be her actual husband. The Gemara clarifies points on the wording of the Mishnah. It says the child is born either first or last, which, as said here, refers to the child being conceived either before or after them being informed of the information, which is particularly relevant in the last case. Also, it says the first case, that the children of a woman who had actually required Yibum and accidentally she had married somebody else, her children are mamzerim, illegitimate. Some people actually disagree with this, as they hold that it's only a violation of a negative commandment involving marrying a relative that can produce a mamzer. There's a dispute between opinions if it's a valid act of betrothal when a woman who required Yibum accepts the betrothal from another different man. It's held that this is not a valid betrothal and she still requires a divorce document. Some say based on this, if such a thing occurs and her brother-in-law was a Kohen, if he does Chalitzah, she can then stay with the husband, as if she was divorced, she wouldn't be able to marry her Kohen brother-in-law anyways. Others say no, as then you're rewarding the husband for a wrongdoing. So actually it says that if her brother-in-law is a non-Kohen, her current husband can divorce her, allowing her to do Yibum with her brother-in-law. We said a woman in this situation's betrothal won't work, but there's a debate if Nisuin, the final stage of marriage, is effective. The final ruling is that betrothal is not valid for a woman who requires Yibum with somebody else. This is discussed along with a related debate if a person can legally do a business transfer on something that doesn't yet exist. It's further debated between several opinions based on several sources. It's further proven from related discussion that a single witness's testimony, if uncontested by any later testimony, is believed in order to allow a woman to marry through Yibum. This is further discussed with additional proofs brought. It also says from the quoted verse, and nor shall they take in marriage a woman divorced from her husband, that even more you can learn from this that a Kohen cannot marry a woman who is divorced from her husband under the stipulation that she couldn't marry anybody else later after she's widowed. She's still not allowed to marry a Kohen. New Mishnah. If someone's wife traveled abroad and he was informed that his wife had passed, so he married her sister, which is only now permitted, but then the wife came back, he can return to his wife, and he and the sister can still marry into each other's families. And if his first wife does actually die, he can go back and marry the sister. If this case occurred, but he had children, and he was informed that his wife was alive during the marriage, but died after, the children conceived before his wife's death are a mamzer. If conceived after, they're legitimate. Others disagree with this principle, saying that anyone who disqualifies others is himself disqualified, and if he doesn't, then he isn't disqualified. The Gemara says in the first case, where his wife vanishes overseas and he marries her sister, if his brother-in-law, the husband of the woman he wants to marry, also vanished overseas, and they then return, the sister and her husband, the brother-in-law, can't be married, but he can still be with his wife. Other people dispute the whole principle from the Mishnah as to whose view it accords with, and it's discussed. He's also allowed to remain with his wife in this case, as he's only violated a rabbinic decree. The sources for this are brought and discussed, and there are related cases spoken on. It also clarifies the ending point of the opinion that says if someone disqualifies others, he disqualifies himself, which means he holds that if he disqualified his brother-in-law from his wife, he's also disqualified from his own wife. And when it said if he does not disqualify others, he's not disqualified, that refers to an earlier case where a woman remarried based on two witnesses and her first husband returns. She's allowed to remarry her old husband, and the sister can remain married to the brother-in-law. There are other similar explanations given on this unique ruling. It also says in opinion that this is the ruling we hold like, but it's disputed. New Mishnah. In the event that a man was informed that his wife had passed, so he married her paternal sister, and then he was informed that she had died, so he married her maternal sister, and he was then told that she died, so he married her paternal sister, and he was then told that she died, so he married her maternal sister, and then he found out that they were all actually still alive. He's permitted to stay with the first, third, and fifth wives, and two of them would be exempt in the event of Yibum or Chalitzah done with the third. He cannot stay married with wives 2 or 4, and if he dies, if Yibum is done with one, the other is not exempt. If by this case the first wife actually had died, and then he married his second wife and so on, he can stay married with wives 2 and 4, and the other would be exempt from Yibum, and he can't stay with wives 3 and 5, and if Yibum is done with one, the other is not exempt. A new topic, if there's a boy 9 years old and a day, if he does Yibum to marry his dead brother's wife, his older brothers can't do Yibum either, and vice versa. However, he can only disqualify his older brothers by doing Yibum, while they can disqualify him by doing Yibum, betrothing her, divorcing her, or by doing Chalitzah. The Gemara clarifies the first cases, as was stated. It also discusses further points on the disqualification between such brothers by Yibum. New Mishnah: if a boy is 9 years and a day old and he did Yibum, marrying the woman, if his older brother of the same age also marries her, the second brother has disqualified the first. Others disagree. If a boy of such an age does Yibum and then also does Yibum to her co-wife, he's disqualified himself from both. Others disagree. The Gemara explains the logic of the disagreeing opinions, that only one of the Yibums could be legally valid, so one would always be permissible. With all of the above cases, it implies that the betrothals would be permissible, but others would disagree with the second case, with the co-wives saying that's not allowed. New Mishnah: if a boy of 9 years and a day does Yibum and then dies, his older brother does Chalitzah and can't do Yibum. Generally, if a minor boy has married a woman and then died, he's exempt from Yibum and Chalitzah. If a 9-year-old and a day boy does Yibum, becomes an adult, marries another woman and then dies, if the boy hadn't cohabited with the first wife after he became an adult, she does Chalitzah with his brother and not Yibum, and the second wife can do Yibum or Chalitzah. Others disagree, saying the brother can do Yibum with whichever he wants and Chalitzah with the other. This all applies by either a boy of 9 years and a day or a 20-year-old boy that doesn't have the necessary signs of physical development. The Gemara discusses these points. It's qualified further, and it also mentions in regard to the non-physically developed 20-year-olds, other similar discussions refer to a saris, a man with an actual disorder, while ours does not. If such a thing occurs, meaning he's not a saris, but he's also never physically developed, he's considered a minor until majority of his years have passed, which is said to be 36 years. Also, it says as general advice, if such a thing occurs, meaning there's a boy who reaches an adult age without having physically developed, it was said to either gain or lose weight, depending on where it's necessary. And that's the end of chapter 10. Chapter 11 of Tractate Yevamos goes through some additional general points in the laws of marriage. The first Mishnah says it's legally permissible for a man to marry the relatives of a woman he had violated or seduced, but he is liable if he does these acts to the relatives of his wife. A man is permitted to marry a woman who was violated or seduced by his father or son, but Rabbi Yehuda says it's impermissible if done by his father. The Gemara says this is a biblical permissibility. Rabbinically, there are stringencies by related situations, and a person is rabbinically only allowed to marry the relative of a woman he had violated or seduced after she passed. Sources are brought and discussed. It also lists a lengthy number of popular riddle-like questions from those times of complex relative possibilities and how they're theoretically possible based on various odd marriage combinations. New Mishnah: if a female convert had sons who converted with her, and one of the sons marry and pass, his brothers don't do Yibum or Chalitzah. This would also apply if the son was conceived prior to conversion and born after, while the brother's conception and birth were after they converted. This also applies by a slave woman whose sons were freed with her. The Gemara discusses some related disputes. This is all discussed further along with some additional points. New Mishnah: if there are 5 women whose children all got mixed up with each other and then grew up, marry, and die childless, in regards to Yibum, their 4 brothers can do Chalitzah with 1, and the remaining can do Yibum for each widow. The Gemara says the Chalitzah needs to always be done first to prevent the possibility of a woman needing Yibum marrying a random other man. Furthermore, the specific case of the Mishnah has to show that it's more preferable that one brother does Yibum with all of the widows to give everybody at least a chance of marrying their brother's widow and fulfill the obligation of Yibum. There are several other variations of this case discussed, and this goes further. New Mishnah: if a woman's child got mixed up at birth with her daughter-in-law's child, and they grow up, marry, and die childless, the sons of the daughter-in-law do Chalitzah and not Yibum with both widows, because it could possibly be their brother's wife, who they can marry, or their father's brother's wife, who they cannot marry. The sons of the older woman can do Chalitzah or Yibum with both, as they could be their brother's wife or brother's son's wife, which are both permissible to them. If the sons whose identities are known die childless, the mixed-up sons of the older woman both do Chalitzah, but not Yibum, as one could be their father's brother's wife, and the daughter-in-law's sons, one does Chalitzah and the other can then do Yibum. If the child of a Kohen got mixed up with the child of her slave woman, both can eat Terumah, but they can only get one portion. Neither can impurify themselves from the dead, and neither is allowed to get married to anyone. If they grow up and free each other, they can marry women fit to marry a Kohen, and they cannot touch dead impurity. Although if they did, they don't get the penalty of lashes. They cannot eat Terumah, but if they did, they aren't required to do the full reimbursement, which is plus a fifth. They don't get a portion of Terumah, but they can sell their own Terumah produce and keep the proceeds. They don't receive a portion of consecrated temple items or kudshim, holy offering meats, but they can keep their own. They don't need to give the select animal portions to a Kohen, and their firstborn animals should be left to graze until they develop a blemish, and they have the stringencies of a Kohen and of a Yisrael. The Gemara further qualifies all these points, and this is all discussed further. New Mishnah: if a woman remarried without waiting 3 months from her previous marriage and gave birth, and they don't know if it's a child from the prior marriage or a premature child from the current one, and she also has other sons from both husbands, the other sons can do Chalitzah, but not Yibum with the questionable son's wife. He does the same to their wives. If the son has brothers from both husbands, but the ones from the other husbands aren't from that mother, and they die, he can do Yibum or Chalitzah with their widows, and if he dies, they can do only Chalitzah. If one husband was a Yisrael and the other was a Kohen, all the stringencies from the last Mishnah also apply here. If both husbands were Kohanim, he would observe the laws of a mourner for them, and them for him. They can't become impure for each other if they die. He does not inherit from them, but they do from him. He is not liable for hitting or cursing them. He can go up to the temple as a part of the Mishmar group of either one, but does not receive a portion of the sacrificial meat unless both husbands were a part of the same Mishmar group. The Gemara discusses these points. There's related discussion. Some say if he hits or curses both fathers, he's liable. Some say if it's done one after the other, which is discussed. It also clarifies the other points, like to establish by the sacrificial meats, it works if the fathers are a part of the same Mishmar group and base of, and he gets one portion. And that's the end of chapter 11. Chapter 12 of Tractate Yevamos starts discussing some of the actual laws of the Chalitzah ceremony. The first Mishnah says, the ceremony of Chalitzah, wherein the Yibum marriage of a widow and her brother-in-law is refused, essentially consists of the reading of several verses from the Torah, the widow removing the brother-in-law's right shoe, and then spitting towards him, which is all brought from verses in the Torah. There's lengthy explanation elsewhere as to why this ceremony is done in such a manner. Anyways, this ceremony must be done before a panel of 3 judges, although they can even be 3 regular people. This ceremony can be done with a minal, a type of soft leather shoe, but not with a sock. It can be done with a sandal, only if it has a sole. It's a valid shoe if it's worn from the knee and down, not from the knee and up. It is a valid Chalitzah if the shoe is not the brother-in-law's, or if it's a wooden sandal, or if it's a left shoe on his right foot. He could also use a shoe that's too large if he can walk in it, or a shoe that's too small if it covers most of his foot. The Gemara explains, it says judges, even though they can be laymen, to say that they must be able to dictate the necessary verses that are read, as judges do. Others say you need a panel of 5 men, which is a dispute based on a verse. It's argued further, but we say we do Chalitzah before 3 judges, as the opinion that said it must be 5 eventually retracted his opinion, unlike by the judges of Mion, by the refusal of an arranged marriage where there's 2. Based on a verse, the location of the Chalitzah must be arranged beforehand. There was also a time when Chalitzah was done before 5, but 2 of those weren't judges. Those were there just to publicize the event, and there are related points mentioned. It also says, based on the verse, that a convert can only judge another convert by such laws. It further qualifies which types of shoes are and are not permissible to be used. There are related points. It says if a woman grew up along with the person she eventually does Chalitzah with, we're not worried that she ever happened to remove his shoe for whatever reason, thus technically doing Chalitzah, and if we saw such a thing occur, there's no worry that that was her intent. There are other points on which types of shoes are and are not permitted, along with sources. It also discusses an instance wherein a heretic tried to compare the Jewish people and God to a woman who did Chalitzah, but it was disputed based on the wording, saying that although the Jewish people have done wrong, our bond is still there. Furthermore, it says that a sock is not considered a shoe, which has relevancy by other laws and has variation depending on the type of sock. This is for the discussed. It also mentions that while doing Chalitzah, your foot must be pressed to the ground, and some say that if your foot is deformed in such a way that you walk on the upper part of your foot, you're not allowed to do Chalitzah. The remaining points are discussed along with sources. This goes further along with additional clarification on exactly which types of shoes are usable. New Mishnah, there's debate if Chalitzah is valid if done at night, and also debate if it's valid if done on the left foot. The Gemara debates why these opinions argue. It said to be that they argue if this is compared to the beginning or end of a monetary trial, depending on if it can be done at night. It also mentions an instance where a sage did a Chalitzah case with a felon felt shoe by himself and at night, the permissibility of which is disputed. The argument on the permissibility of using your left foot for chalitzah is based on the explanation of a verse. New Mishnah, if the shoe was removed and she spat, but she didn't say the verses, it's a valid chalitzah. If she said the verses and spat but didn't remove the shoe, it's an invalid chalitzah. If she removed the shoe and said the verses but didn't spit, the validity of the chalitzah is debated based on the interpretation of a verse. If either the woman or man are a deaf mute or the male is a minor, it's not a valid chalitzah. If a minor girl did chalitzah, which means she's rejecting the marriage, she must redo it later as an adult. If she didn't, her earlier one is invalid. If the chalitzah was done before 2 judges, or 3, and one was found to be disqualified, it's disputed if her chalitzah was invalid. Once there was a widow and brother-in-law in prison, and they did chalitzah by themselves, and it was ruled to be valid. The Gemara says that we said the verses aren't necessary, however the deaf mute still can't do chalitzah as they aren't legally considered to be mentally competent. A regular mute also cannot, as they need to be fit to speak. It also says, if the widow spat at one of the brothers, she then needs to do chalitzah as we're concerned that was her intent. This is debated. This is all discussed further along with several related points. It also says if the widow spits blood, she then still needs to do chalitzah as there was definitely spittle included. It's further debated if it's legally accepted if a minor does chalitzah, and it cites a related incident. It says that the oldest a girl can do chalitzah, the rejection of a Levirate marriage, is when she's older, having reached certain stages of physical development. The other points are further discussed. The case of the chalitzah in the prison cell was said to have a witness outside, which was how they knew about this whole thing. It was also said that the entire incident and the ruling of the case took place in the prison. Therefore, there are additional cases discussed and a few additional qualifications, such as an argument if the judges need to be able to recognize the man and woman doing chalitzah. New Mishnah. In regards to the exact order of chalitzah, it's that they first go to court, and as the verse says, and the elders of the city shall summon him, and they shall speak to him. This means that they're advised, for instance, if there's a large age gap, they're advised to not marry, and that they should do chalitzah instead. They cite the relevant quotes from the verses. My Yavam refuses to establish a name for his brother in Israel. He is not willing to take me in Yibum, and the other says, I do not want to marry her, and this is all said in Hebrew. The verse then states, Then his Yevama shall approach him before the eyes of the elders, and she shall remove his shoe from upon his foot and spit before him. And this means that the spittle should be visible to the judges. Then the verse says, And she shall declare and say, So shall be done to the man who will not build the house of his brother. Although some have said that they would read the entire chapter, and that's what the custom was established to be. The verses then finish, and his name shall be called in Israel, the house of the one whose shoe was removed, which is what he's then referred to, although his students don't have to, and others say that everyone there must say that. The Gemara clarifies these points, and further says exactly what they need to say with which words. It also describes the Chalitzah document, and says that the scriptural verses can be written on it. The spittle must be at least level with his face before it blows away. If that occurs, she must spit on her own without chewing stuff beforehand to help. The judges must see the spittle. The remaining points are clarified, and that's the end of chapter 12. Chapter 13 of Tractate Yevamos discusses the laws of Mion, which is that in the event that a family arranged for their minor girl to marry somebody, it's instituted that the girl, when she becomes of age and the marriage is about to go into effect, she can refuse this marriage if she wants, nullifying it completely in a process known as Mion. The first Mishnah says, Beis Shammai holds that you can only do Mion for an Arusa, someone in the first stage of marriage, while Beis Hillel says you can do it while in any stage of marriage. Beis Shammai says it could be done towards a husband, while Beis Hillel says it could be done towards a husband or for Yibum, the Levirate marriage. Beis Shammai says it has to be done in the husband's presence. Beis Hillel says it could be done without him. Beis Shammai says it must be done in court. Beis Hillel says it does not. Beis Hillel says she can do Mion, refusing to marry as many times as she wants. Beis Shammai says she just should do it once and then must wait until adulthood to marry. The Gemara debates the logics and sources behind these opinions, and they're all discussed further. New Mishnah. Now, all of this applies if the girl was being married off by her mother or brothers, that she can decide to refuse the marriage if it was done with her consent. If it was done without her consent, it's just not considered a legal permissible marriage in the first place. Some say that if she's not capable of safeguarding her betrothal article, it's not permitted to marry her off. Rabbi Eliezer says, if, God forbid, somebody tries to marry a minor, this is not legally binding. He has accomplished nothing. For instance, if a Yisrael's daughter is with a Kohen, she may not eat Terumah, and if vice versa, she may still eat Terumah, basically meaning, as stated, that the marriage is not legally acceptable or permissible, really, so nothing is accomplished legally. Some are of the opinion that if the restraint is due to him, they are considered married, and if the restraint is not due to him, they are not considered married, and it's going to explain soon what that means. The Gemara describes the exact text that's written in this Miyun document of refusing such a marriage, and there are further particular cases discussed. It also describes how if a man tries to marry such a minor, as described, it's considered completely illegal and not legally binding, explaining how all of the typical laws of marriage do not apply. The opinion in regards to if it was due to restraint, which what exactly that means is debated. Some say it could mean that if someone gave her a divorce document, that's called restraint due to a man, and she's not allowed to marry his relatives or a Kohen, but if she refused him, this is restraint not due to a man, as mentioned, and she would be allowed to marry his relatives in theory, or a Kohen. This is further described. New Mishnah, if the minor refuses the husband, they're still legally allowed to marry each other's relatives, and she can still legally marry a Kohen, unlike by if he gives a divorce document. If he gives her a divorce document, asks her to remarry afterwards, and then she refuses him, then eventually marries somebody else and is widowed or divorced, she's legally allowed to marry the first husband. If she refused the first husband and then later married him, and then divorced and then married somebody else, and was then widowed or divorced, she's forbidden to remarry the first husband. Generally, if a divorce document is given at a point after Miyun was done, they cannot eventually remarry, and if it's vice versa, they can. If the girl refused to marry the man and then later married somebody else and then divorced and then went to somebody else, refused him also, and then eventually married somebody, got divorced, and then refused somebody else, she's legally allowed to remarry anyone she left via Miyun, but not via divorce. The Gemara discusses these points. New Mishnah, if someone divorces a woman, remarries her, and then dies childless, there's disagreement if she can do Yibum with his brother. There's also disagreement if this is done by an orphan girl. If a father marries off his daughter, and she's then divorced, she is considered like an orphan, so if she's remarried by him, she cannot do Yibum. The Gemara further qualifies these points, along with the logic behind the differing opinions. New Mishnah, in the event that two brothers have married two minor sisters or two deaf mutes, which are all non-biblically recognized or permitted marriages, and one of them dies, the other one cannot do Yibum or Chalitzah. If one sister was an adult and the other husband died childless, the younger sister does not do Yibum or Chalitzah. If the other husband dies, some say we tell the minor to refuse to marry the husband, so that way he can do Yibum. Some say she can just wait until she becomes an adult, at which point the marriage will now be recognized biblically and permitted, and the other sister won't need to do Yibum anymore as she's now a wife's sister. Others say he needs to divorce his wife and also do Chalitzah. The Gemara says here it's allowed to encourage her to do Miyun to allow the fulfillment of a mitzvah. This is related to an opinion which says you should cleave to Chalitzah, making peace between people, and revoking vows, while staying away from Miyun, accepting deposits for safekeeping, and acting as a guarantor for a loan. These points are all further expounded on. It also talks about the importance of judging properly. If somebody's a judge, and if he is, he should always view himself as if there's a sword resting between his thighs with Gehenna open beneath him, which is based on a verse. The other opinions are also discussed. This is all qualified further, and decides we rule like the opinion that in the above case, we encourage a minor to refuse the husband, so that way they don't marry, so that way they'll separate and he can just do Yibum. New Mishnah, in the event that somebody was married to two orphaned female minors or two deaf mutes, a marriage, again, not legally recognized by biblical law or permitted, and he dies, Yibum or Chalitzah with one releases the other from the requirements of Yibum and Chalitzah. If he was married to one and one of those, Yibum with one does not release the other from Yibum. If he was married to a mentally competent individual and also a deaf mute, Yibum with the mentally competent woman releases the deaf mute, but not vice versa. If he was married to an adult and an orphaned minor, again, only the adult marriage being biblically recognized, Yibum with the adult releases the minor, but not vice versa. The Gemara further debates these cases. This is all discussed further, and there are additional points on these brought. New Mishnah, again, by a biblically non-recognized marriage, if somebody married two female minor orphans or two deaf mutes and died childless, and one does Yibum and then one of the brothers does Yibum also with the other one, the first one is still valid. This wouldn't apply if one was the orphan and one was the deaf mute. If one wife was mentally competent and the other was a deaf mute, if the first did Yibum and then one of the brothers did Yibum on the second, the first is still valid. With an adult woman and a minor, if they do Yibum with the adult and then the minor, the adult's Yibum is still valid. If they do Yibum with the minor and then the adult, the minor cannot be married through Yibum. Some say we instruct the minor to just refuse the marriage. The Gemara says, again, we follow the latter opinion that we instruct the minor to refuse the marriage, and this needs to be repeated as here Yibum was actually already done. New Mishnah, if a minor did Yibum with a minor, we wait until they both become adults. If a minor boy does Yibum with an adult, we also wait until he becomes an adult. If a woman, after doing Yibum, says she didn't cohabit within 30 days of them living together, we compel him to do Chalitzah. If this was after, we request that he does Chalitzah. If he admits he didn't cohabit, even if it's way after, we compel him to do Chalitzah. If, while her husband was alive, a woman took a vow to not benefit from her brother-in-law and then finds she needs to do Yibum with him, we compel him to do Chalitzah. If this vow was made after her husband died, we only request that he does Chalitzah. If her intent was to avoid Yibum, then we only request for him to do Chalitzah, even if it was made during her husband's life. The Gemara further clarifies these points and discusses some related ones. This goes further along with bringing some specific cases which are discussed, and there's additional qualifications on all of this. And that's the end of Chapter 13. Chapter 14 of Tractate Yevamos continues discussing the law in situations of various different types of marriage. The first Mishnah says, if a deaf mute marries a mentally competent individual, as the deaf mute can't speak, when they marry or divorce, they can do so through gesturing. If a woman became a deaf mute after the marriage, they can still be married or divorced. If the woman became mentally insane after the marriage, he's not allowed to divorce her. And if the husband became a deaf mute after the marriage, he can never divorce his wife. It says a woman is different than a man here by a deaf mute, as a woman can be divorced with or without her consent, while a man can only be divorced with his consent. It also says that a woman who became a deaf mute after marriage is similar to a deaf mute girl whose father married her off, that she also can be divorced. If two deaf mute brothers are married to two deaf mute sisters, or two regular sisters, or to one sister who's a deaf mute and the other's mentally competent, or to two deaf mute sisters married to two regular brothers, or to one deaf mute brother and one mentally competent brother, in all these cases, if these became a widow, they're exempt from Chalitzah or Yibum. If they aren't related, then the other should do Yibum. They're able to also divorce. If there are two brothers, one is a deaf mute and one is mentally competent, who are married to two competent sisters, and the deaf mute brother dies childless, the widow does not do Yibum as she's a wife's sister. If the competent brother died childless, the other must divorce his wife and can never marry anybody ever again, as he's stuck, unable to do Yibum or Chalitzah. If there are two competent brothers married to one sister who's a deaf mute and one who's competent, if the deaf mute's husband dies childless, the other brother doesn't need to do Yibum, as the widow is his wife's sister. If the competent wife's brother died, the other must divorce his wife and do Chalitzah. If there are two brothers, one deaf mute and the other competent, married to two sisters, one deaf mute, the other competent, and the deaf mute brother died, the competent brother doesn't do Yibum, as he'd be marrying his wife's sister. If the competent brother died, he must divorce his wife and can never marry for the same reasons as before. If there are two brothers, one deaf mute and one competent, married to two unrelated competent women, if the deaf mute brother dies, the other can do Yibum or Chalitzah. If the competent brother dies, he must marry the widow and is never allowed to divorce her. If there are two competent brothers, one is married to a competent woman, the other to an unrelated deaf-mute woman, and the deaf-mute's husband died childless, the other should do Yibum and is allowed to divorce her later if he wants. If the other brother died, the other could do Yibum or Chalitzah. If there's a deaf-mute and a competent brother married to an unrelated deaf-mute and competent woman, if the deaf-mute brother died, the other should do Yibum and is allowed to later divorce her. If the competent brother died, the other must do Yibum and can never divorce her. The Gemara says there was a rabbinically instituted category of marriage for a deaf-mute maid, as they can have normal lasting marriages, but not for an insane person, as their marriages can't function. We also said we don't institute a category of marriage for a minor boy, as unlike a deaf-mute, the boy will eventually become allowed to marry as an adult. The institutions for a girl that she can be married off by her family in the event that her father dies, with the clause that she can refuse it if she wants to, was something instituted as protection for the girl, as back in those days, at least, without her father to protect her, there was a concern that people would take advantage of her. Therefore, it was instituted that if her family consents and she doesn't refuse it, she can be married, to be put into the care of another individual. Definite women don't have miyun apply to them, as men would be deterred and don't want to marry them in the first place. There are other practical differences mentioned between the two, and there are additional cases discussed. There's also discussion if you're obligated to stop a minor from committing a sin, like if you see a child about to violate Shabbos, if you need to stop them, which is debated, and there are several proofs brought, and is further discussed. And that's the end of chapter 14. Chapter 15 of Tractate Yevamos discusses further points in the laws of a widow whose husband vanished overseas. The first Mishnah says if a woman went with her husband overseas and they weren't having any marriage issues and she came back and reported that her husband had died, she can do Yibum. If they weren't having marriage issues, but the world was very chaotic at the time with wars, or they were having marriage issues and there was peace in the world, she's not believed if she says her husband died. Rabbi Yehuda says we only ever believe her if she comes back crying with her garments torn. The rabbis say we believe her even if she doesn't show signs of mourning. The Gemara clarifies points on the wording and says the issue by wartime is that she might have seen her husband injured when he actually survived. It's also said that famine is even stricter than wartime, that a woman is only believed here if she says she actually buried him. A building collapse, snakes and scorpions, and some say a plague are similar to wartime by these laws. This is discussed. There's further debate along with some specific cases where a fire burnt down a couple's house and the woman escaped, saying her husband was inside. Even if you find a burnt corpse in the house, that's insufficient to assume it's the husband, as he also could have escaped, and that corpse could have been somebody else. And there's further debate on these laws, and there are additional unique cases brought. It also defines what constitutes argument between a couple by these laws. Some say it's at the point where the woman says that she was divorced before a witness, although the witness denies this, and this is further debated. New Mishnah. Beis Hillel says we only believe a woman that her husband died to allow her to remarry if she comes from the grain harvest and in the same country. Beis Shammai says she can come from any harvest or any country. A grain harvest was mentioned as that's what the discussed case was dealing with. Beis Hillel retracted his ruling to rule like Beis Shammai. The Gemara qualifies these opinions and cites the full case about the grain harvest, that some people went to harvest wheat and a snake bit one of them, and the wife testified about it, and there are related cases brought. New Mishnah. Beis Shammai says when we say a woman can remarry from her own testimony that her husband died, she can also get her marriage contract. Beis Hillel says she does not. They argued on this. Beis Hillel retracted his opinion. The Gemara further debates these points. New Mishnah. Everyone is believed to testify for a woman that her husband died, besides for her mother-in-law's daughter, her co-wife, her husband's brother's wife, and her stepdaughter. They would be trusted to testify on her husband giving her a divorce document, as that's a written document. The Gemara says these women can't testify as they'd be hostile to the wife for various reasons, which are further explained. New Mishnah. If one witness says her husband died and she remarried, and then another witness says he did not die, she can stay with her new husband. If two witnesses testify that her husband is alive, she must leave her new husband. If two witnesses say he died and one says he did not, she can remarry even after this testimony. The Gemara clarifies points on these laws. New Mishnah. If two co-wives went overseas with their husband, and one says he died and the other says he did not, the one that said he died can remarry and collect her marriage contract, and the other one cannot. If they give different testimonies as to how he died, one saying he died naturally, the other saying he was killed, some say they can't remarry, some say they can. If one witness says he died and one says he did not, be they man or woman, she cannot remarry. The Gemara explains the logic of these cases. New Mishnah. If a woman went with her husband overseas, returns and says her husband died, she can marry and get her marriage contract, but her co-wife cannot remarry based on this. If the husband who vanished was a Kohen and the co-wife was a Yisroel, she'd still be allowed to eat Terumah. Others disagree. If a woman went overseas with relatives and testifies that her husband and father-in-law died, she can remarry and get her marriage contract, and her mother-in-law cannot. Again, there's debate if she can still eat Terumah in that circumstance. The Gemara explains the necessity of both cases, as there's variation based on the hatred between relatives. It also says we hold up the opinion that they can eat Terumah, which is sourced. New Mishnah. If someone betrothed one of 5 women and he's not sure which, and they all say it was them, he divorces all of them and drops the marriage contract between them and just lets them figure it out. Others say he must give each of them the marriage contract. There's a similar argument if someone stole something from one of 5 people. Some say he just drops it off between them. Others say he must give one of it to each person. The Gemara again clarifies further points. New Mishnah. If a woman went overseas with her husband along with a child and then comes back alone saying the father died first and then the child, she's believed. If she said the son died first, thus requiring her to now do Yibum, she is not believed. To be safe, however, she must still do Chalitzah. If she says that she had her child born while overseas, she's believed if she says the son died first, but not if she says the father died first, in which case she'd still require Chalitzah to be safe. If she went overseas with her husband and says he had a brother born there and says both died in either order, she's believed. If the brother went with her overseas, she's not believed if she says both died in either order. This is explained. The Gemara cites some related discussion. It also says if someone gives a divorce document to his wife through a third party and there's conflict, we assume the woman would have preferred to stay married. Similarly, it says a husband who is extremely short or has an undignified profession, like combing wool, or has flawed lineage, will all remain married, although there's a concern the wives will be unfaithful. And that's the end of chapter 15. Chapter 16, the final chapter of Tractate Yevamos, discusses some final laws on a widow whose husband vanishes overseas. The first Mishnah says if a woman's childless husband and her co-wife went overseas and she's later informed that her husband died, she cannot get remarried or do yibum until she figures out if her co-wife was pregnant. If a woman's mother-in-law went overseas, there's no concern she has a child, requiring her not to do yibum, unless the mother-in-law left while pregnant. Others say it's still not a concern. The Gemara further qualifies these points and opinions and debates their logic, and this is discussed further. New Mishnah: if the wives of two brothers return from overseas and they both say their husbands died, neither is allowed to marry somebody else out of concern their brother-in-laws are still alive. If one has witnesses, she can't remarry while the other one can. If one had children, she can remarry, unlike the other. If they did yibum with their other brothers and those also die, there's debate if they're allowed to remarry. The Gemara discusses further similar cases, and they're additionally qualified. New Mishnah: in regards to testifying the identity of a dead man to allow his wife to remarry, they must have seen the form of the face, including the nose. Without this, they can't even testify based on identifying marks or the body or clothes. They can only testify if they see him actually die, not if he's just badly injured or even mid-hanging from a gallows or being eaten by an animal. They can only testify on the corpse if they saw it within 3 days of him dying. Others say the time frame is variable as it depends on the corpse or location. The Gemara further describes the necessity of which facial parts must be identifiable. It also says how you can't identify based on a body mark like a mole, which is debated. There are further specific points discussed, and it describes how a person in theory could survive a serious wound after being presumed dead through cauterization and similar. It also says you can testify that person died if you saw him being eaten by an animal at a vital part of his body, which is described as parts of his throat. This is further discussed. New Mishnah: if somebody falls into a body of water and is not seen to emerge, no matter the size of the body of water, he's not presumed to be dead. An incident is cited where somebody fell into a large water cistern and came out 3 days later alive. Some say based on an incident, if you see somebody submerged in water and you watch the bank for long enough for him to drown and he doesn't emerge, you can assume he died. There's also an incident where somebody was lowered into a sea and they retrieved only his leg, and it was said that he was only assumed dead if it was severed above the knee. The Gemara defines these bodies of water and cites some related incidents. It also mentions some other lethal events, disagreement if somebody falls into a pit of snakes if they're considered dead. It says somebody's considered dead if they fell into a pot of boiling wine and similar points. It also cites an incident where the daughter of a ditch digger fell into a cistern, so they kept going to the sage Rabbi Hanina ben Dosa for help, and he kept saying it was fine, and then the third time he said she had emerged, and she had, claiming that an old man with a ram had let her out. They asked Rabbi Hanina if he was a prophet, and he said, no, it just doesn't make sense that a righteous man should have his child punished through the good things he had done. This ditch digger's son, nevertheless, still died of thirst one time, as God is extremely exacting still, based on verses. New Mishnah: if a person hears somebody else saying that somebody died, he can testify that the man died. Some say even if he heard his kids saying that they were going to eulogize and bury him, it's allowed. These words are accepted whether they were intended as testimony or not. Some say we only believe an idol worshipper if they didn't intend to testify. The Gemara further clarifies these points along with citing some related cases, and this is discussed further. In New Mishnah: witnesses can testify that somebody died whether they saw him by lamp or by moonlight. You can also allow a woman to remarry if they just heard but didn't see somebody testifying to her husband's death, and it cites some particular incidents. The Gemara discusses these points, and it asks, what if the person that she heard was a demon? And it says that, in that case, it must be where she saw at least the man's shadow of a shadow, which it said that demons cannot fake. New Mishnah, it gives the list of all of the sages who argued whether we believe a single witness's testimony that a husband died, and all of the opinions on this. And the Gemara further discusses these opinions. New Mishnah: Rabbi Akiva said we don't allow the testimony of a woman, slave, or maidservant by these laws. It cites an incident which seems to imply otherwise, but Rabbi Akiva said that was where the witnesses brought many identifying possessions of the individual. The Gemara further discusses this incident with a few particular points and ends by quoting a verse which says that Torah scholars increase peace in the world. And that's the end of chapter 16 and the entire Tractate Yevamos. Alright, that was a lot of information. So here's a rough summary of a lot of the practical takeaways from this tractate. The Levirate marriage is a very unique form of marriage. Essentially, if a wife is left widowed without any children, her remaining brother-in-law is obligated to marry and take care of her in a process called Yibum. In the event that they don't want to go through with this marriage, they don't have to, and perform a ceremony known as Chalitzah. There are various types of marriage which are forbidden, either biblically or rabbinically, for various reasons. Forbidden people to marry include relatives, secondary relatives, a Kohen Gadol marrying a widow, a Kohen marrying a divorcee, various converts from specific nations, an illegitimate individual, people with reproductive issues, people lacking the necessary mental capabilities, like a minor or insane individual, and many others. There are unique leniencies to allow a potential widow to remarry easier. Typically, almost everything in Jewish law requires 2 witnesses. One of the exceptions to this is that if a woman's husband vanishes and is thought to be dead, she'll be allowed to remarry and not be stuck questioning if her husband's actually alive or not through the testimony on the death of her husband by a single witness. And that's about everything. Thank you so much for watching.